Yes.
One matter, my lord, that national highway work has been stalled by, my lord, stopping my quarry activity. Therefore, there is the same day, my lord, notice has been issued for demanding certain amount on the same day by granting 15 days. Same day, by virtue of not non-paying, on same day it is stalled. And there are 60,000 metric ton material is available. Therefore, we can use that. Therefore, my lord, that I am moving. Can have it.
20. Disposed of writ appeal, my lord. Disposed of writ appeal, my lord. Wherein, my lord, appellant has been challenged the order of impugned learner single judge, my lord. The respondent submitted that they have made arrangements to the students of the SLC students, my lord. Thereafter, and also they have produced stated
Arrangement for?
arrangement to the SLC students, my lord, to take up the examination, my lord. And also they have submitted that impugned order under challenge. They have already passed the order by the respondent number one. That two of the matter was disposed of, my lord. But no liberty, I was under the impression was liberty was granted to the appellant to challenge the impugned order passed by the respondent number one after the petition order, my lord.
Who has not granted liberty? We have not granted.
We have made submission, my lord, granted liberty, but unfortunately.
Is it a review petition?
Not review petition, writ appeal, my lord. In the writ appeal, my lord, when the VAT was posted for admission, my lord.
Understood.
Please, my lord.
Now you want that order to be reviewed.
A modification of the or clarification.
Filed a review petition.
Yeah, for modification of the order, my lord.
Any examinations are there?
Examination is over, my lord, but the impugned order with the respondent number one produced at the time of hearing, my lord. Admission, my lord, they have produced the order, my lord.
It will be listed. No, don't submit any memo. It will be listed. Get it listed at the appropriate time. Yes. Yes, madam.
Matter is already disposed of, my lord.
Yes.
It will be listed. File IA. No, memo will
I
not
have filed
accept.
my IML.
My lord, this is the custody matter that my lord heard at length. In here, I feel some two minor items are there. One is that the mother was supposed to bring the child on 4th. In one place, it is written as 5th. If that one correction could be made. And my lord said, in fact, stated that the matter get immediately after vacation.
No, that we have, that for some reason we have kept. We have kept this side, but the children may not remain present, nor the parents' party remain. Will not hear in absence. It is kept. You, the councils may remain present.
Yes.
For that date, you may move the. Move this.
And the 4th April, 4th May, can I think that should be one place it is written as 5th.
You have to move that. Not for speaking. What is this called? Being spoken. Being spoken to.
Or I can make that submission on 24th since my lord
No,
did it on that day.
on that they will correct.
Plus 24th, am I supposed to keep the part?
When it is kept,
Not
23rd.
required.
It is kept on 24th April, next week. It is kept on 24th.
Public interest writ petition to save a civic community site not from the encroachers. Writ petition not is dismissed for default. Application is filed not seeking to recall not the orders.
And go before learner single judge.
No, it's a PL. PL before.
Dismissed for default.
Yes.
By us. Previous bench.
Yes, bench.
Move I. Will get it listed. Relates to relaxation in fee.
High security registration place.
High security place. It can wait. No.
Maybe I take him at 2:30, my lord. So already listed at 56.
After vacation.
It is posted today, my lord.
Why
It is
are you
today.
moving? It's there.
So why you are mentioned?
Your lordship had granted me the liberty to move it in the morning when the matter.
That will. So liberty is exercised by you. Yes, no, this can wait. It will be subject to outcome. Withdrawal. Monday at 2:30.
Why can't you use a mic so that we can hear what you are saying?
Not listed, but then listed Monday, what is? Yes,
My lord, one submission, my lord. In one contempt matter, my lord, the matter was closed, recording the submissions of the accused that they are going to comply. My lord, the affidavit filed, my lord, is not in the nature of complying the order. Liberty was given to me, my lord, to move this honorable court if they have not complied the order. I filed an application to recall the same. The lordship may kindly take up next week if possible.
after that. Yes,
Any date after vacation,
it will come. After vacation, new dates.
please.
My lord, contempt fresh matter, my lord. As per the court order also, the accused will not issue the TDR to complainant, my lord. Right? And my property is acquired for public purpose, my lord. Till today also not issued TDR. my lord.
After vacation. After. Yes, yes.
My
yes,
lord,
ma'am.
it's too,
Your lordship.
Fresh matter. AIDB has unilaterally cancelled an allotment to plan and library. I was enjoying the benefit of an order during the course of the writ petition. Subsequently, the petition closed. What has happened is now they're trying to re-allot the land to another, in favor of another third party, my lord. I've already
This
paid.
PIL.
No, my lord, writ appeal.
Writ appeal.
I've already paid a consideration of about 6 crores. If they
This
allot
can,
it to a
this
third
can
party,
wait.
my lord, it's had next week, my lord, because they are going to allot it to a third party. I'll use the.
All right, 23rd.
Oh.
Yes,
Lord.
This is the PIL, my lord. I am carrying the government order granting 60 acres of land, Goma land to the electric subcenter for establishing. Though it is already a very less than 50% of the reserved area, my lord. I am carrying the 60 acres is not sufficient. 7 acres is sufficient for establishment of the
after
subcenter.
vacation. Yes,
They have started the work, my lord. Now they have started to work.
after vacation.
Lords, my employer sent a communication that I will be superannuated in February 2024. But on the basis of recording the wrong date of birth, which is a clerical error, I filed writ petition. I am supposed to be retired in December 2024.
After vacation.
My lord, it's a contempt petition, my lord. It's a fresh matter. The complainant had filed a WP seeking Podi and Durasti of the complainant's property. It was allowed in favor of the complainant, but despite giving several representations, an endorsement also was issued to conduct Podi and Durasti, but till date it has not been done, my lord. That's why contempt is filed.
After vacation.
Your lordship, contempt fresh matter, your lordship. Petitioner is not allowed to visit his child from the last 3 years, my lords. Even there is
And
an
what you
order
are
from the
doing
High Court.
After 3 years, you are mentioning.
No, there's an order from the High Court, even though they are not complied with the order of the High Court.
After 3 years, you are.
No, recently writ petition is disposed, my lords.
When it was discussed.
20 days back. 20 days back, my lords. So writ
20 days back.
is,
So what you are doing for 20 days?
my lords.
All of a sudden, you are.
My lords, there is an order from the trial court as well as my lords. They have not complied with the order of the trial court as well. From the last 3 years, they are not allowing me to visit my child, my
Your
lords.
father or mother?
Father,
Father.
please.
And
From
where
the
is the
day
mother
one.
and child is where?
Hello?
Mother and child is where?
Yeah, well, my lord.
Where are they?
Where are
Mother
they?
and
They are
child.
in Bangalore, sir.
Bangalore.
Please.
You are also in
I am
Bangalore.
also in Bangalore.
24th.
Please.
Yes.
Lord, this writ appeal, interim stay was granted to applicant 2 years back. After that, in multiple hearings, someone has not been served yet. This may be listed and they may be directed for carrying out paper publication, my lord, because I'm for respondent.
That this can wait.
Where is the urgency?
My lord, it's affecting the life of respondent number 7. By
Immediately after reopening, it will be released. Yes.
My lord, by mistake, one case has been posted before this honorable court where my Lord Justice Dikshit was
66. 37,
serial number
38, and
37.
another 62. 62. 3 matters are there.
No, not before.
maybe posted as early as possible because already 13 years of lapse.
Yes, Mr. Patil.
Yes, sir, 14%. Sir, mine is a joint purchase property, sir. The single judge has passed a order in favor of one owner only. So he has come for dispossession. So I have filed a writ appeal, but it is in still my FR number 577, sir. It requires petition copy, sir. They have not issued the petition copy also. So I applied, but the copy is not.
So you approach the register
No.
judicial, not us, not to the court. Yes, no, don't
Has
take
come
any.
for
memo.
dispossession.
No, we're not taking any memo, Mr. Patil. Yes, anybody else?
My lords, kindly if I may move for an adjournment. Serial
Yes.
number 43, my lords, the matter pertains to Chittadurga Matta. There is no urgency in view of the development before the Honorable Supreme Court. The accused number 1 and 2, my lords, are excluded from the affairs of the Matta and the Vidyapita both. In view of which there is no urgency, the matter may be had.
When it reaches, you mention.
Please,
The
my lord.
contempt matter, na?
Content matter.
Let us see when
Please, ma'am.
this weekend.
Please.
Lord, serial number, Lord, may make serial number 30, my lords, next week.
1-3.
130. 30.
Yes, what do you want?
Lord, next week, my Lord, I have some incoming.
Next week, beyond vacation. Yes,
Serial number 11 as well as the serial number 55, my lord. From this.
so what do you want?
The appellant.
What do you want? Why you are mentioning? Adjournment beyond vacation.
Serial number 53, your lordship, we are seeking short accommodation. We
Beyond
have filed,
vacation, after vacation.
Sir, I'm a part-in person, filed a PL against BBMP. This is 2022 matter, and the hearings are going on. All the documents were submitted by both parties. Now I want the next hearing, sir, to discuss the point.
Regarding
It's I'm talking about corruption and BBMP activities.
after vacation.
Lord, serial number 4646.
Yes,
Lords, may I seek the matter if it can be taken up on 24th or 25th minutes?
after.
Short.
vacation. No.
Obliged.
Your Lordships, kindly, my lords. If I may be permitted to mention,
Yes, madam.
my lords, for adjournment, my lords, serial number 51.
Your voice
My
is not
lords,
clearly reaching us.
my lords, serial number 51, please, my lords.
51, yes.
Please, my lords, I appear for KV to respondent 3 and 4, my lords. My lords, my grandmother has passed away, my lords. May I please request for another date, my lords?
Time you want? Do you want adjournment?
Please, my lords. Please, my lords. I've informed the other side, my lords.
After vacation.
May I please request for a date, my lords?
Date will be given. Which day? 10th of June.
Please, my lords. I'm grateful.
Number 1.
My lord, I appear for respondent number 2, my lord.
Day before yesterday, they filed an objection and an application for vacating. Some
No,
logistical problem.
How come that this appeal comes under the office objection along with
In
council?
fact, I requested for listing on top of the list last time, my lords.
But it is meant for hearing.
It was meant for hearing, my lords. That's, we are ready, my lords, in that matter.
That is the only. Yes, proceed.
Only thing is, my lord, if they are relying upon the objection statement, my lord, I would want it to be taken up, my lord, on Monday. Because there's some logistic, they gave us, my lord, the objections.
Right now?
No, 2 days back, my lord.
Day before yesterday, my lord.
Let him.
Logistical problem
And
because.
tomorrow will start.
Tomorrow.
They have time. Monday. But because this, without hearing on merits, this order is operating. So
Yes,
whatever order
yes.
may be passed, continuance or otherwise, but after hearing on merit, that is the end.
Yes.
only insight.
Get him to fly down here.
Tomorrow, my lord. Grateful.
being spoken to, seal number 2.
My lord,
Number 2.
my lord, in this matter, while the matter was heard on the last time, my lord, it was.
What you are complaining is the part of the order of learned single judge, and it is confirmed.
Confirm. At that time, when confirming, my lord had observed that it was given, opinion was expressed that the RTC entry would be retained in the name of the father, my lord. And it was, that was if it was observed, my lord, and with that observation, it will be disposed of. That was given to understand at the time when it was disposed, man. Both of us are brothers, my lord. We are.
But then we want us to reverse the entire order.
No, my lord, we don't want to reverse the entire order. Only what I request is, we both are. Yes, my lord. Yes, my lord.
19.
In the light of the observation made herein above,
You are saying subsequent to the impugn order that will restore the same as it was. So this is what we are.
my lord, before that, what happened is, while the court has directed to restore in the name of, before AC and DC passed the order. But before that, it was in the name of the father only. Without hearing us, they have passed this order. So we request only that father's name may be there. We'll contest the civil suit. And if the civil suit decides, anyway, we'll abide by.
You are defendant.
Defendant.
You are sorry.
Yes, my lord.
You are sorry.
My lord, I am the plaintiff. I am the plaintiff in that suit, and he is the defendant, my lord.
Then
It's a suit for-
that will be, the entries will be subject to
Yes.
outcome of this
Yes,
suit
madam.
under proviso to section 135.
Yes, ma'am.
Please read
Yes.
Yes.
on the Land Revenue Act.
Sorry, madam.
Land Revenue Act, as interpreted by Justice Govind Bhatt bench,
Yes, ma'am.
says where you have filed a suit,
Yes, ma'am.
in terms of the decree to be passed in the suit, the entries in the revenue records will be mutated.
I want, that's only a request, my lord.
Considered the memo for being spoken to and also heard learned advocate Mr. So-and-so, so-and-so. Full stop. From the order impugned in the writ appeal passed by learned single judge, it could be noticed that learned single judge has directed inter alia that if mutation entries were changed consequent to the impugned orders, the Tehsildar shall restore the same as it was prior to the impugned orders, this order of learned single judge paragraph has been confirmed by the bench dismissing the writ appeal. Therefore, the submission in the memo for being spoken is not well conceived. However, since the parties are already before the civil court, in respect of the titular right, it is clarified that the decision rendered by the civil court shall govern the revenue entries.
Contempt matters, seal number 3, the GS Venkata Subbarao.
Petitioner. Directions, my lord, annex page 20. And my lord, they were directed to consider the representation, but pursuant to the decision taken by them in the.
Only the issue of being spoken to or it is taking heart into even like
Seal number 3.
Petitioners. Directions at page 20, my lord. Second respondent.
Notice 12th of June, learned government advocate, Mr. Indra, accept notice for R1. R2.
Publish.
Seal number 4, Abhimanyu.
Writ of mandamus Milots was issued against the accused number 1. Writ of mandamus Milots was issued against the accused number 1 Milots. The order at page number 69 Milots, issued to the respondent state government to reframe clauses 7, 10, and 11 in the annexure to the government order dated so and so, in terms of the observations at paragraph 6 of this judgment, and report compliance to the Registrar General of the court with an outer limit of 3 months. With regard to this, we've also issued a notice to the accused number 1 Milots. No report yet.
That they have not complied.
Not complied.
Was it before the apex court?
No, Milots.
This matter was affixed before the apex court. It appears. Just go check.
I will take instructions on it.
Some appointment.
Please, this is regarding to the appointment of the chairman of the KSPCB and the related.
Pollution control.
Please, Milots.
The appointment is not done.
Milots, the appointment was stayed, Milots. The mandamus was with respect to the clauses in the government order, Milots.
Second respondent. Mahendra.
Copies are not served.
State of Karnataka, second respondent.
I will serve the copies.
Notice returnable on 14th June. Learned the government advocate, Mr. Mahindra. 2.
Notice to the respondent 1 note. Accused number 1 notice. Please. Great.
So, PL matters. Seal number 5, Shiv Shankar K.
Sir, appeal for the petitioners. That's the petitioners. That's are the residents of the same locality. That's the respondent number 6 has purchased the building. That's consisting of ground floor, first floor, second floor, and third floor. Now he wants to fix the mobile tower on the building. That's without seeking permission from the authorities. Adjacent to Milots, the property of the respondent number 6, my property, the several buildings are existing, and Milots, there is a temple and school is existing. Now the respondent number 6 wants to fix the mobile tower on the top of the building. But it causes Milots all, it's the front of that Milots, there is a temple, school, Milots, and Milots, the building is a very old one. That's we have already given representation.
Are you withdrawing or you are inviting order? If it is to be subject to our order, then will be our order. And you will not complain anything about the order and the directions and whatever we impose. Besides, for such purpose, there can't be public interest litigation. Secondly, it is purely a private interest litigation because of your own environment. Go to your memo.
It's all the, it's permit to withdraw and then let's.
Withdrawing?
Yeah.
Dismissed as withdrawn.
Liberty to Milots file.
You are the adjoining person staying.
Yes, Milots, but.
Your own.
Yes, please.
Whatever other remedy you want to exhaust, you exhaust, but not public interest litigation.
Seal number 6, Vijay Shekhar Gowda.
Petitioner, please. My lord, the petitioner, questioning the inaction of the second respondent with the Chief Commissioner of the BBMP, wherein, my lord, respondent number 9, Chief Auditor, he has pointed out that, my lord, the respondents 10 to 11.
Who are you? What is your locus and status?
I am the citizen of
You all are citizens. We are also citizens.
Yes, my lord.
But we would not like to enter in such a petition.
He is a taxpayer. My lord, kindly permit me to say.
Withdraw. Learned counsel.
What up, my lord?
Withdrawing?
No, I will argue, man.
You want inviting order, then please argue. It's not difficult. We consider that. But
No, my lord, I respond
this
number
is the
9.
first reaction without being concluding anything. Yes. Yes, what is it?
Respond number 9,
pointed out
So
that.
some GST is not paid and bills are
Yes,
prepared.
madam. Yes, madam. Close together, madam, scam has been
How
taken.
did you come to know about all these things? From your friend who got some audit report, some paragraphs were there, you studied the paragraph. Wow, what kind of interest you are cultivating?
Madam, can you see the respondents 10 to 12 have colluded with the respondent number 13 to 15.
Some
who being
Venugopal, your
contractors.
friend Venugopal, one Avinash, got obtained audit reports prepared by the 9th respondent, chief auditor. They were your friends. You got the copy of the report, then studied the report, then filed this petition. Very long petition.
Close together, madam, a scam has been taken place. In spite of.
Whether
madam,
disciplinary inquiry should be held or not, essentially a matter of
Yes,
service
madam.
jurisprudence.
Inquiry to be held.
How
madam.
can we? You know that, at least half a dozen judgments of the apex court holding
The second
disciplinary
respon-
inquiry is part of any service law textbook will say, matter of disciplinary inquiry relates to service jurisprudence. Then how can you maintain the PIL? Explore other avenues.
If we entertain such a PIL, then we are superimposing our own view over the disciplinary inquiry or employer.
They have to come
or the
before
authorities who are entitled to take their own view in accordance with law.
They have not deducted the CGST, GGST and
We can't explore all.
ESI and PF.
It is domain of the employer or the inquiry of.
The respondents 13 to 15 men who are the contractors.
And there is no reason,
taxes.
there is no reason to presume that they will not act in accordance with law. That they will not take any action against the erring persons.
That the respondents came before this honorable court and filed their version, please, madam. Madam, can you issue notice to all the respondents?
Dismissed.
Name, huh? The land bearing survey number.
Appealable order.
It is
Divisible
available
order.
before NGAT because it's an, it
33.
is interdepartmental communication. A letter addressed by DCF to the senior geologist.
Interdepartmental, that is also correct, yes.
Let that
Are you
objection
acting
was
upon
raised,
that?
Millet. It affects me. He has withdrawn the NOC on the ground that it is a deemed forest land. Now he has given NOC, your lordship may kindly see, Millet, it's annexure M, page 115, Millet. The senior the Millet range forest officer, assistant conservator of forest, deputy commissioner, they submit a report saying that these are all Millet. Gomar land is not a forest land. Millet, on the basis of a report in Deccan Herald paper, annexure A is passed, withdrawing that NOC given, Millet. Page 115 is Millet. Translation is at 117, Millet.
But it's an appealable order.
There is no appeal provided
Appeal
against this
provided
order,
for
Millet.
this.
No, against the order passed by the forest officer. Appeal lies before NGT Milad under 2A of Forest Conservation Act 1980.
And it is wholly, let my learned friend show under which provision of law this is appealable, Millet. It is not an appealable order because.
This is interdepartmental communication.
Millet, even if it is interdepartmental communication, it affects me. Because he has withdrawn and consequently my application will be rejected.
So it is not culminated
And
into.
it is given to me also, Millet.
It has not culminated into order.
Millet, it will, automatically it will. It is communicated to me, Millet, is at page 24, Millet.
No, competent authority has not passed any order.
No, this court, I think KLJ 1984, 2.
Please.
Yes.
Mere interdepartmental communication per se will not give a cause of
Now it
action.
is communicated.
If it is acted
That's
upon, then that 84 KLJ,
Yes.
the division bench has said like that.
No, it has not been acted upon.
No, communicated, then it becomes order.
Order.
Yes.
Yes, communicated.
Purely interdepartmental from one table to another, we are not much bothered. But when you communicate it, it's being acted upon to the prejudice of rights of the citizen. Then
Yes.
it takes different color.
Lord, you'll ask me kindly peruse section 2A of Forest Conservation Act.
Forest conservation.
Rules, Lord, there is.
Forest Conservation Act.
1980.
Then it is without.
Even otherwise, my lord, the application of the petitioner in this matter is an ineligible application. And similar matters are posted on 22nd.
22nd
April.
We'll have that matter.
But so far as this issue is concerned, Lord, against this order.
Appeal to National Green Tribunal. Any
Yes,
person
Lord.
aggrieved by an
Any
order or
person
decision
aggrieved by an order or
Third
decision of
section.
state government or other authority made under section 2.
appealable order. Who is the author of the order?
Deputy Conservator of Forest.
But this order is made under which provision of this act?
Under the forest conservation.
Not any order under the sun. It should be an order relatable to one of the provisions of the act or to the policy content of the act. 53 Supreme Court. If it relates to policy content of the act, even if you have not stated the section, that pales into insignificance.
That's true.
Now related to policy content.
Lord, here, on the basis, all that he says in this letter is, Lord, the extent of the deemed forest area, he is to be determined.
Correct.
Till then, Lord, he has withdrawn the no objection.
The section. Which section empowers him to do that?
That is
And
under
if it
rule
is a
8, I'm sorry.
If you want to argue his
No,
case
no,
also
I'll-
very well,
I'll-
we are most welcome.
I'm sorry.
My submission is, Lord, if it is a deemed forest, Lord, Forest Conservation Act applies.
No, which section? You have to relate.
Section 2.
Section?
2 of.
No, order now made. Section 2.
Please.
2, that the dictionary clause of the act.
Yes, sir.
Which subsection clause?
Section 2 reads this. 2, restriction on the de-reservation of forest or use of forest land for non-forest purpose.
Without permission of the central government. Now, wherein it fits, the order made?
Lord, here he is seeking quarry in the area which is according to the forest officers is a deemed forest.
For deemed forest, you are supposed to issue any notification.
Not necessarily, Lord.
How?
Because, Lord, we have filed an affidavit before.
How somebody would know that this is the area of deemed forest boundary?
That is a government land.
No.
Government land, basically.
Earmark the boundary by some method of statutory instrument.
Lord,
or order or circular.
that exercise has been taken up by a committee constituted by the Supreme Court in Godavarman's case.
And have you done something pursuant to Supreme Court observation?
Yes, Lord.
Which includes this area to be part of the deemed forest?
Yes.
It is being looked into. It is being looked into by the committee.
Yes.
That's the impression you gave other day.
Yes, yes. It has been looked into, and earlier it was 10,000 hectares.
That's all.
Thereafter it has been
No,
revised.
no, brother. Till a decision is taken by the committee, how can you interdict the activity?
No, it has been taken. Decision has been taken. We have filed revised affidavit before the apex court, and we have notified 330,000 hectares.
That interim order was there. Interim order of the Supreme Court.
Yes.
Approving your affidavit.
This land,
Yes.
let my learned friend
No,
produce.
we want to know whether this land is enlisted in the affidavit which was filed before the apex court in 2014. 17, 14 and 17.
Yes.
There are two affidavits. Whether this land figures
my
as one of
mind,
the
my lord-
items in the affidavit,
Yes.
you show that.
Milord,
You
to
file
my
your
mind,
counter
Milord,
here.
this is,
Your last may kindly have it on 22nd because similar matters are there.
Not if.
Lord, if in this case, we need not go into this aspect of the matter since it is an ineligible
In
application.
principle, we accept your stand.
Please.
But to be correct on principle, to
Demonstrate.
dismiss the petition or to take any decision on part, there must be some concrete thing.
Please. I shall.
At least your affidavit saying that this is included in.
Please, I shall. Last may have it on 22nd.
Monday.
HM, Muralidhar?
Lords, I have sought for a writ of mandamus to pass order pursuant to the order passed as per Annexure A.
Now, why they are not executing lease deed?
They are not executing. At each stage, they want court order. My application for querying lease is of the year 2014. They did not issue license. Then I had to approach this honorable court in 2019. Pursuant to the direction.
Did your lease expired?
Pardon me, lords?
Did
Whether
your
your lease has expired? No.
No, license is granted, but unless they execute lease deed,
You
I'm
cannot
not
work
supposed
the-
to, I'm not supposed to come.
What is? You having issued license, you do not execute the lease. What they should do with the license?
We have not issued.
Not issued license.
No,
Not issued license.
that is the crux of it. That is, we are asking whether your lease is granted, expired.
No.
Otherwise, there is no good reason for them not to execute the lease deed. There must be something.
Lord, now by the virtue of 2023 Act rules, Lord, since the area is less than 2 acres, here the lease is sought for an area of 1 acre, which is not permissible under.
Whether 23 is retrospective in operation?
No.
Then how can you apply it to the applications which are
we are-
made anterior to amendment?
My submission is, Lord, we are going to execute the lease deed post 23. Post 23. Now we have to execute.
So this is not intended to be.
Because area is less than 2 prescribed.
Area is?
Minimum prescribed area is 2 acres.
Say 2 acres.
Now he is seeking lease in.
But we have held, I vaguely remember having read one judgment where you have argued that the 23 amendment rules are prospective in operation.
True, Lord. It is prospective in nature. My submission is, Lord, it has to be seen in this light, because we are going to execute a lease deed pursuant to the.
File.
Please.
Notice to the respondent returnable on 13th June. And the statement of opposition to be filed by respondent of.
Please. Next also.
Number 9.
Next also similar.
Similar.
Same, yes.
Number 10. Abhijit.
My lords, I am for the petitioner, my lords.
You don't want to wear the gown. We can hear a groundless lawyer, but not groundless case.
I'm very sorry.
Wear the uniform, na? You're in the first.
Please, I was in the traveling, sir, so I did not carry my gown. So I am doing the hearing from my friend's office. So I do not have my gown with me right now, sir.
Also not wearing right now. You come with the dress and wherever you want to come. either
Uniform.
physical.
Let the matter be
Monday?
passed on, Your Honor. I'll borrow a ground from my friend and make a submission.
Or like password. Password.
11 urgent. Seal number 12. J. Sima KP. Writ appeal matters.
11 is.
Point, my lordship.
The case of the appellants are, my lord, is the land which was acquired and aimed to be a lapsed, Your Honor, as there was no subsequent any developments till date. And the land acquisition was in 1988, Your Honor. And the appellants are the purchasers of the land
Your
from the
subsequent-
original owners.
Subsequent purchase.
Yes, pursuant to the. It is not subsequent purchaser, Your Honor. It has been wrongly taken as the ground as subsequent purchaser due to the following reasons, Your Honor.
When did you buy the land?
1997, Your Honor.
97, sale deed, date of sale deed,
Date original, from the original landowner is
registered sale deed is
registered sale deed is on 23/4/1997, 15/3/1997, 22/1/1997, and 26/4/2000.
when preliminary notification was issued,
It was issued in 1988, Your Honor.
1998,
1988,
88,
88.
23rd
But-
March 1988, my lord.
27, 3,
23.
88. 23, 3, March.
1980.
Then you are a subsequent buyer of.
No, Your Honor. In the meantime, writ petition 4810 of 1995
Yes,
by this honorable court's order, the final notification in the year 1994, both were quashed.
they were quashed.
They were quashed.
Then what happened?
Then subsequent notification by the respondent 2 and 3 was in 1999, Your Honor, 5/4/1999.
Fresh notice.
Subsequent to
Fresh
sale
notification.
deeds.
Your Honor. Your Honor, it may be also taken up.
Our learned advocate, Miss, what's your good name? Miss
Ambika is-
Your name?
Ambika is for Jason.
Notice returnable on.
My lord, I
You take notice for?
Respondent number 1, my lord.
One.
My lordship, interim order to be
it will be
granted, Your
June
Honor.
18.
Otherwise, they will dispose us
June
me
18.
on the ground that we are subsequent purchaser. Their
Did you have
contention
interim
is-
order at the
yeah.
hands of the learned single judge?
No, Your Honor.
No, let us, let notice come in.
There is a urgency, Your Honor, because there is no development in the particular land and we have been curtailed by the, not even getting the roads, Your Honor. It
Let
is
us-
inside the city.
Let us, see. It's very old matter. Let notice go.
19 June. December 13, Mr. Srinivas V.
I appear for appellant in this case, my lord. My lord, the revenue entry with respect to 8.5. My lord. My lord, the appellant have called in question the order of the learned single judge where the order of the assistant commissioner and deputy commissioners have been set aside solely on the ground that the land have been converted and it loses the nature of a character of a revenue and it has to be done before the other appropriate authority. Based on that, my lord, the revenue entries have been set aside. Now, my lord, the appellants were not issued notice before the learned single judge, my lord, firstly, my lord, and secondly, my lord, based on the statement, in fact, the land was sold in the year 1938. About 8.5 guntas was left out. Thereafter, my lord, in the year 1973, the statement was made and pursuant to which land was mutated. Again, my lord, in the year 1997, the brother of the petitioner therein have made a statement before the revenue authorities.
Once land is converted to non-agricultural, will it be catapulted outside the precincts of the 1964 Act?
My lord, they will only mention, that land is converted for non-agricultural purpose. In the middle, my lord, in column number 12, they have to mention that it is converted for non-agricultural purpose. My lord, the rest of the kata will follow in the other appropriate authorities only, my lord.
No,
But for farming of the kata, I'm sorry, my lord.
Is there conversion order?
Yes, my lord, in the year 1970.
Order.
Yes.
What will happen pursuant to conversion order is consequential.
Yes.
So there is a conversion order. What is the fault with the reasoning of the learned single judge?
My lord,
Once it is converted,
yes,
except one lone view, which again is not well reasoned, the consistent view of this court is it goes outside the precincts of the 1964 Act.
my lord,
Mr. Holla, that is the legal position. That's the legal position. So what is?
my lord, my lord, my lord, for appropriate authority to make the khata, my lord, the basis, my lord, one last submission.
There's only one point. This appeal matters. Should not take much time. If there is meritorious, we only will grant relief.
My lord, my lord, it may be disposed of with, my lord, observing that the khata, before filing of the appeal before the Assistant Commissioner and the Deputy Commissioner, it was standing in the name of the President, my lord, one Shivramu. If the RTC is restored in his name, and let them approach the civil court, my lord. The reason why I am before your lordship is, my lord, the respondent
amounts
was
to-
a honorable governor earlier, my lord. We can't.
Please, you are seeking entries in a particular way in the name of particular person. That will be done under section 127 to 135. Therefore, we will be applying the 1964 Act to the fact matrix of the case when they are miles away from the act because of the consequence.
My lord,
Outside the
It's perfectly good, right?
The only reason why we approach this, if the RTC is restored in the, as it was.
To do that,
even
we have to
before-
apply the act. That we cannot do.
Dismissed.
This is a matter wherein.
Number 14.
In fact, they had thought that the matter could be settled.
This one.
This one, but your lordship, they haven't been able to come towards settlement. It's a matter wherein, in fact, substantial time was also spent by the Honorable Court in trying to bring about a settlement.
So you want time?
No, your lordship, we'd
settlement
like, no,
happened.
we'd
No
want to proceed with the contempt. In fact, this is third round of contempt. In fact, the last time Honorable Court had said that this time they will discount what she has done, but on the next occasion, if she continues to do so, that we would be.
Earlier, the joint memo.
May I, please?
Just 2 minutes. May I submit? From the intervention of your lordship, one sitting did take place, my lord. Subsequently, the matter.
This was a matter which I mediated in the chamber.
Yes, my lord, yes. In fact. Plus, in fact.
And since then, the father has not seen the child.
I
We were very
have-
grateful that at that point was the only
I have
time.
mediated,
Please.
therefore I cannot be part of the adjudicatory
But
process.
this can be settled, my lord. In fact,
Anyway, there is some dispute now.
no,
Like-
there is no dispute. Whatever he has agreed before your lordships were in contempt, his lordship was grateful enough to hold 3 sittings, and whatever he has suggested was put.
Now that is disputed now.
Nothing-
Therefore, it has
no
to go
reasons
before
were
some.
given,
No,
so
no, no.
They just.
Not, it's not no reasons.
No reasons have been given.
No, no. You can't ask for a one-time settlement and a maintenance also.
Huh?
Your lordship, what had happened is subsequent to your lordship.
So what is the now difficulty? Anyway, we will not.
Your
be-
lordship, in fact, Justice Shivshankari Gowda also sat in this matter. He said that a 1 crore one-time settlement could be. Now, what they say is we'll take the 1 crore, but we also want the monthly maintenance and it just, your lordship, this is, your lordship, we would not even.
Whatever he had agreed before his lordship was put in the agreement and shared. Now they, without assigning any reason, they
No,
say
no,
there
no,
is no
that
settlement.
is
In
not.
fact, my lords, sorry, in fact, my lords, I just feel with your lordship's intervention for just 5-10 minutes, I think this can be settled. That is all. Because she's there, I think even if just 5 minutes, my lords, there is no.
I have no
All
objection to
right,
that.
anyway, you can have a chance because I mediated.
Yes,
Absolutely.
I think this can be settled. my lords.
The registry shall list the contempt petition, this contempt petition
Might I request it in this coming week before the other?
before Any other bench, after taking appropriate orders on the administrative side.
Your Lordship, the difficulty is this is exactly what they wanted. 2 months of vacation. Again, the father would not be able to see.
We'll
the
try
child.
to list in the next.
Please, obliged, obliged.
For complaint, but they have not complied the order. Although there is a specific direction, not the passed by the learned single judge. Not the fact is this, not of the petition, not the complainant's land, 5 acre, 24 guntas was acquired by the BDA in the year 2004. And not neither paid the lot of the compensation nor lot of the released the lot of the developed land to the lot of the complainant hearing.
I'm appearing for the
Complainant
complaint, my
hearing.
lord. I'm
And
appearing for
Lord,
the accused, my lord. My lord, one Shri Dr. Prakash Chand Prash has filed the writ petition in the same scheduled property and he sought for not to disperse the compensation to any other third parties, my lord.
There is an order now.
No.
He got the
Lord,
interim
he
order
is
of CM.
claiming sites no.
We're asking.
May I make submission?
Come to page 17, 18.
Please.
They are the mandates.
Yes.
Have you complied with the same?
Lord,
Or
I have-
is there any justification for non-compliance?
Yes, but the another person claiming to be a owner of this property has filed a writ petition. There is an order of, interim order by this honorable court, not to discuss a compensation. In that writ petition, I have already filed an application before the learned single judge seeking for a permission to deposit the amount before this civil court. My learned friend's client has filed an impleading application. But on the last occasion it had come up, the learned single judge suggested that it is a competent civil court which can adjudicate. Writ court cannot adjudicate whether he is the owner of the property or the other person is the owner of the property.
Lords, may I make submission? Lords?
That
Lords,
is
the
also listed today.
Lords, acquired land.
Also posted today.
It is listed today before the learned single judge.
Lords, may I make submission? Lords?
Now what? It matter is before the
Lords,
learned
that
single
is
judge,
in
you have
respect
sought
of
for
site.
impleading.
Lords, Lords, that is in respect of site. It is not the in respect of 5 acre 24 guntas land. Lord, they're not claiming not the entire.
Then it is for that, yes, yes.
You get impleaded.
No simultaneous hearing.
Yes, madam. Yes.
Hearing on application, seal number 16.
Please, my lords. Because this is a disposed of contempt petition, which was disposed of by the order dated 9th October 2023. We had filed certain original documents, my lords. We are just seeking return of those original documents which were on record, my lords. Because they were invoices and other product which was filed. It was a contempt regarding an infringement order which was passed against the respondents accused. So we had also filed certain originals on the record.
Interim order. It is interim order.
Against interim order it was.
Yes, my lords. However, this was disposed of, my lords. The contempt was disposed of by order dated 9th October 2023, saying that order 39 rule 2A would be the right remedy and liberty was granted to go before the court which passed the order.
Correct.
Yes, ma'am. So, my lords, we are only seeking the return of documents which were filed, original documents, because we need to produce those documents before the court.
He wants documents to be returned. Only for it. Please be- Any original documents were produced? Brother,
Yes, my lords.
which original documents?
My lords, they were products, my lords, and invoices.
Huh?
There was product, the infringing products and the invoices they were produced, my lords, along with the list of document.
Yeah, original documents have. can be, original documents can be directed to be returned, not
Right.
other certified copy.
Right, not others, my lords. Only originals I am saying.
Present proceedings, the complainant has filed application under order 13 rule 9, read with section 115 of the Code of Civil Procedure 1908. Praying for return of the original documents filed in the contempt. Reasons are stated in support of the prayer. The documents are necessary to be produced before a private court. Registry shall permit the complainant applicant to take back the original documents, which may have been filed. The registry house shall retain the authenticated copies of such original documents, which may be returned to the. In the authenticated copy inter alia shall be at the signature of the applicant also, certifying that they are the copies of the original which are returned.
Number 17. It should be.
But there is a challenge to the constitutional validity. It has to be heard, my lord. There is a.
Be heard at length.
Will have to be heard at length.
Respondent number 3.
Naturally.
I'm appearing for the petitioners in this case, my lord.
So this has
We've-
come back from the Supreme Court?
Yes,
my lord.
Where is the order of Supreme Court? Justice
But
Vagela.
earlier, my lord, the lordships had held that it should go to NGT. That order was set aside. And Honorable Supreme Court said the High Court has to decide.
Justice Vagela's order is.
Yes, yes, yes.
Set aside.
Yes.
So this 2012 SCC which was relied on by Justice
Yes,
Vagela, is not accepted.
In fact, most of the prayers have become infructuous, but nevertheless, there is a challenge to the
Validity
constitution.
will remain.
So will hear after it.
Yes.
Nidhi, give me the date of the Supreme Court.
Yes.
My lords, we were not able to reach our clients due to medical emergency, so we didn't get any instructions.
Any other agenda?
Yeah.
You're at Jen.
After vacation.
Much obliged, my lords.
Number 18. Ganpati Bhatt.
It's the safer zone. Safer zone, my lord, and deemed excess.
Whether section 6 process has to be freshly undertaken or the other day which you had argued, that's the case.
Not only that, Lord. The reasons for rejection is that, Lord, it is within 45 meters from the major district road. Major district road notification was of the year 2006.
Before the license was granted.
Yes. Kotak. Serial number 4. serial number 4 is from NH4 to Maidala route to Urdigere road.
These roads are upgraded.
These roads are upgraded in the year 2006. This notification is of the, is dated 31/2006.
This is under which legislation?
This is not,
Which is the law which regulates
After that, my lord,
designation of roads, upgradation of roads, which is the law? Because its impact we have to look into.
yes, Lord, I shall clarify that aspect, Lord, but the fact remains, this has been upgraded in the year 2006 itself, and it is a major district road as of now. That is not in question. Here, Lord, Annexure R, last may kindly peruse Annexure R. The
Now, why we are asking this is,
Please,
the apex court said in 3 judgments, where rights are created by lease, license, etc., in favor of a private citizen, those rights cannot be silenced by orders issued in exercise of executive power of the state. Therefore, our question assumes significance. If it is an order made under the statute, then it partakes different character.
My submission is that this notification is of the year 2006. And license, initial license was granted in the year 2013.
Correct. After this order.
After this order.
Therefore, we want to know what is this order, its status, its efficacy level for the rights of the private citizen.
Lord, this is not in dispute. Major district road is not in dispute at all.
Because in Bijo Emmanuel, 86 Supreme Court differentiated orders issued in executive power, orders issued under the statutory power. If they are pure executive power, then rights otherwise available to the citizens cannot be curtailed, is the view of the apex court. Therefore, you have to say under which this will assume importance. Number 1. Number 2, you had granted some largesse, some license, some lease. After this order, nothing is changed now. If that is so, can you deny right of renewal? Because this is not a new thing. It was there already when you had issued that.
That is the point. That is the point. Because at the time of issuance of the earlier notification, this particular aspect is not taken into consideration.
You formulate and develop it.
Please.
You can't simply deny relief that way. And you have to show whether this was published in the official gazette so that citizens, the notice to world at large, because of 92.
Please.
That you have to show. You cannot simply saying that
it appears not it is under
when it was published,
162, I should clarify.
These things you have to show. Otherwise, it will not take effect at all. Unless it is published in the official gazette, it will not take effect at all. That's the law. Subject to some exception, 3 exceptions. Statute. If it is no statute, then obligation. Publicity. Yes, these things you have to answer. After. Mr. Holla, we'll have it after occasion because larger issue is. Please.
Vijay Shekhar, I represent IAPR for the respondent.
this matter could be
Matter-
heard after, my lord.
May, well, the matter may have to be heard, and it is, I can put it in a very narrow compass, subject to the orders of this
Matter
honorable.
could be disposed of after main matter.
Senior advocate is.
Please.
Let us.
Please.
I have prepared a small synopsis. ಅವ್ರಿಗೊಂದು ಕೊಡಿ, synopsis. ಕೊಡ್ರಿ. ಅದಲ್ಲ, ಅದು ನಾನು- But how I intended to put is only in a very narrow, in a preliminary notification under KIADB Act, name of the appellant was shown. And in the final notification also, the name of the appellant was shown. Subsequently, what happened is, no award has been passed. No award has been passed. There, no doubt, my lords, in the initial stage in the writ petition, the petitioner has prayed that because of long delay, etc., set aside the preliminary and the final notification under KIADB Act was our prayer. Now, my lords, I'm taking a little smaller relief. I'm seeking a smaller relief in the sense that there is an endorsement to the effect that award is not passed and no amount is paid. If they can pass an award, and if there is any dispute between the two parties, let the matter be referred to the.
Any award was passed?
My lord, in fact, I have taken a contention, my lord. The lordship may kindly.
Not
see-
contention. Show the
My
award
lord,
to us.
award is passed, and in between that, my lord, this one Senthil Rani, as per the revenue records and sale deed, my lord, they are the owners of the land. That is the reason, my lord,
Where is the award?
no, that I will produce, my lord. That whether we have discussed it or I am not aware, but we have taken that contention.
No, whether award is passed or not cannot be a matter of contention.
Yes.
It's a matter of record. Where is the award?
Yes, that I will produce, my lord. We have taken that contention.
may
We
I-
have taken that, but we
May I
have
pray,
passed
my
the
lords,
award.
page number 160 to 162 of the paper book. There is an endorsement to the effect.
No award is. No award is.
I mean, no, words used are, the amount has not been dispersed. There is no records to show that amount has not been dispersed.
1 second. You are saying that award was passed.
Yes,
Where is that?
my information is my.
Not information. Show
My
the record.
My lord, I have stated in that my statement of objection itself. my lord.
Makes no sense.
Yes.
Apex Court said, if a question arises before the court, whether award is passed or not,
Yes.
what we should see is
Yes.
the copies of the award, nothing. No, by argument, we cannot bring the rain from the cloud.
Please, my lord,
Yes.
that we have taken the contention, my lord, but if
You are
award.
only repeating.
my lord, if
Where is that award copy?
My lord, if award is not passed and not dispersed, my lord, we will take necessary steps to disperse the award amount. It is not this one, my lord. That I will get instruction and this one. So far as award is concerned.
Division bench judges. The scheme of acquisition under the 66. Much rights that within 5 years for vesting. Section 28. The landowner will not be able to tap the compensation. Nothing will be compensation. Very discreetly, they will go on doing this. Some judgments are there. Very clearly they are criticized. They are criticized. Therefore, he has to show whether there is award or not. Saying that if we have not passed award, we may be directed to pass award. Is not going to help the cities. Again, he has to come before the court. They should say when the award was passed. when the
One
possession was
second,
taken,
please,
when
Lord,
the
sorry.
payment was made. These things are matter
Yes,
of
Lord,
record.
as on that date, my lord, that is the reason super.
What my brother is saying.
That I will get, my lord, that if
No,
award is
where
not
the
passed,
award- Where is the award passed?
that I will produce, my lord, because I've taken that contention, but it appears we are not dispersed because of the internal dispute between the petitioner.
We do not know all
That,
that.
this one.
We-
But
we
as
are-
on the date of this,
The KDB cannot act as the land robber. At least
Not
two
like-
judgments we have said
not
like
like
that.
that.
We have said like that.
yes.
We have said like that.
Yes, I agree.
Therefore, you should show, when you are taking the land of the citizen,
Yes,
you should show, we are taking your land, we are giving compensation. This is the award. Have a copy with you.
yes,
Where is that?
that award copy is not there.
By argument, we cannot prove the award.
Yes,
If
I
you see award, show the award.
please, I'll get, my lord.
Let them show.
Let me-
Otherwise, That's the shortest
No,
grievance
Manoj,
which you
may I
want.
only pray that could it be recorded so that it will be easy for me?
Immediately after vacation,
No,
we'll have.
after 10th of June, my lord may kindly fix up the date,
Yes.
but an observation may be made that KIADB is required to produce the award.
When do you want?
Please, my lord, that. After occasion, I will get it. My
11th
lord,
June.
my information.
11th June.
11 June.
Please,
Okay.
please.
Number 20, regarding non-filing of complaints, change Devendra.
What happened to review petition?
Review is pending.
After 19th June.
Number 21, Kevin Narasimhan.
They are complied with?
Yes, Lord, we have complied the order. I shall place it on record, Lord.
Something was to be done? Something remained to be?
No, we have mutated the RTCs also. Last may kindly pass over, I'll produce the RTC.
If you have done, we'll record that and dispose of it.
My instructions are that,
They are saying that they have done everything.
My lord, kindly pass on, my senior will come and address the matter.
2:30.
Grateful.
Complaints in contempt, still number 22, Mr. Srinivas B.
Lord, I appeal for a complaint in this case. Lord, affidavit have been served now to me.
What was the order?
Lord, it was a reimbursement of GST, GST amount, my lord, which I have paid to the department. Page number 51 is the relevant directions, my lord. I take your lordships to the page.
You have
number 51.
complied with that order?
My lord, what
No,
has
my lord,
happened?
Not complied.
Not complied.
I have filed the affidavit, my lord. To the, my lord, we have passed the endorsement saying that, my lord, the details as to what he has paid to the GST must be furnished. Accordingly, my lord, the amount would be paid. That is the endorsement passed by the.
Lord,
26/3/24.
Yes, my lord.
that has been served now to me, my lord. My lord, he in the affidavit, he states that paragraph number 3 of the affidavit, if your lordship, may I take your lordships to para 3 of the affidavit, my lord. The complainant has not submitted any such comprehensive representation as directed by this honorable court. This is the contention he takes, and thereafter he says that he has served this notice to me. My lord, if your lordship can kindly take my representation, which is at annexure B, page number 53.
The representation was available in the records, my
Please.
lord, according.
You asked him one copy.
We have
Whether
given
your representation is not being reflected in our file, give a copy of that.
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ ಅದನ್ನ ನೋಡ್ಬಿಟ್ಟೆ ಮಾಡಿದ್ದೀವಿ.
Like Israeli, my lord, in detail, I have stated what is the amount I have paid and how much I have to receive and how much the department have agreed to pay at the first instance. It contains full details, my lord. In one breath, he says that he has not received the representation, and another breath, he calls upon me to file the comprehensive representation again. Now, my lord, I have no hesitation to give one more copy of this to him. Let him consider within a reasonable time, my lord. Let him consider, my lord. I'll give one more copy of this one to him. If he wants it to be certified by my CA, I'll get it certified and file it to him, my lord. Because this statement is prepared by my CA only.
ಅಲ್ಲ My lord, the representation is very much in the file. Accordingly, my lord, they have considered that representation and passed the order.
Order is not passed. He only says in this blood, the rates quoted by the contract shall be deemed to be inclusive, so and so will perform so in this rate as per the applicable law. As per clause agreement, you are herewith instructed to submit the difference in taxes duly certified by the appropriate tax authority for the further process. My lord, I will furnish, my lord, again, if you want, I will furnish it again, my lord, with,
Come to 50, 50. Last paragraph.
I'm sorry, my lord. Yes, my lord.
Read.
Liberty is reserved in favor of the petitioners to challenge any order or decision
No.
passed.
50, internal page 42.
Yes, ma'am, I'm sorry.
Roman 3.
Petitioners are
Roman
directed to submit comprehensive representations to the respective employers or respondents within a period of 4 weeks from the date of receipt of a copy of this order, irrespective of whether they have completed the works pre-GST or post-GST, or payments were received or yet to be received post-GST.
When did you file that?
My lord, representation, my lord, I have filed little belatedly, my lord, on 15 June 2023, my lord. My lord, annexure B, my lord, page number 53. Within 1 week, within 8 June was the order, 15 June is the representation, Lord. Lord, in this, Lord, we have, Lord, paragraph number, in page number 54, only, in the, there also we have stated clearly, Lord. In the, we humbly beseech the benevolence to acknowledge and accept this claim and undertake the necessary action as mandated by the Honorable High Court order. We have attached detailed work calculation of GST reimbursement as annexure A and B as per the Honorable High Court order. Now, my lord, this we have worked out and we have given, my lord, annexure A and B to them along with the representation, my lord, including the works what we have executed and what was the tax due and what was the tax liability and what they have to pay, the difference.
The authorities, my lord, will give a certificate as to what amount he has deposited. Accordingly, my lord, that is what he has been called for. That is why if he gives that certificate. In
Comprehensive representation is stated, we have given.
all
Now,
other
if he
cases,
wants
my
that,
lord,
what is the tax paid by me on the said works contract, I am ready to give, my lord. I will give it to him.
Where have you give comprehensive representation?
My lord, this is the comprehensive representation.
No, tax amount, tax component you have to specify. How much
Yes,
you
my lord,
have
we have
paid.
certified in annexure A, my lord, annexure A to the representation. If your lordship can kindly come, my lord, pre-GST figure, pre-payment details, my lord.
These are the payment details.
Yes, my lord, these are the
Yes, they
payment
have given.
details.
Allah, authority
Gross
will
virginal
follow.
value of the contractual total,
It is his own
10%,
certificate.
RA bill.
1 second.
You solicit whatever details.
Whatever details he has furnished.
Yes.
Why do you say he has not furnished details? You should have asked him what other details you wanted in addition to this.
Allah, authorities have to file. My lord, GST authorities hatra iವರು ಏನ್ ಮಾಡಿದ್ದಾರೆ cross check ಮಾಡಿ, he has to get a certificate as to what is the amount he has deposited.
You can ask the GST authority. Citizen, he complaining like this. Kindly furnish us these details. That exercise you are not done. Obviously for some other reason. Obviously for
My
some
lord,
other
I'm not-
reason.
Because my lord, if your lordship gives me time, my lord, I ask them to do it, my lord. If your lordship, what has happened, my lord, it is not the only case wherein others have given these certificates, my
No,
lord.
rightly or wrongly, they have got an order at the hands of the
Yes,
learned judges. Now, you are saying you have not furnished any component. They have furnished the component. See the annexures to the annexure
Yes,
B.
ಅದನ್ನ ನೋಡೇ ಮಾಡಿದ್ದು ಇದು.
What is the requirement? Where you stated
But
these
what they say is, my lord, your lordship may,
something more. What officers, perhaps these officers want something else from.
my lord, may I request, my lord, may I request, my lord, your lordship may call it next week, my lord, I'll find out and I'll
You will
find
do-
out, my lord, I'll definitely.
But not this way.
Yeah, I
You-
definitely, my lord.
Not this way.
I'll call the concerned person and.
We'll give you some more time. You come out with
Yes, my lord.
the positive things.
I'll
You
do
can't
that.
harass the citizen. We are against it. Tell your officers, this is, we can assume something else. Do will not say that now.
No, my lord, I'm not.
Otherwise, we'll ask him to be here. You know what we will do to him.
7th June.
Yes.
7th June.
Here for petitioner. Please.
matter pertains to the construction of STP project. Earlier, the resolution was passed by the corporation, amount of rupees 204 lakhs were.
Very old matter.
Very good.
4 5 years.
Application.
This can therefore wait, that is the only.
Please.
11th of June.
This is number 24, Shaji Kulle.
Please, my lord.
Yes, what is the urgency?
So the respondent number,
Yes.
the urgency is only let them consider my request. I have produced all documents at annexure F, my lords. If learned
application.
Yes, my lords. MOF council can consider my request, my lord.
The lapsed, please.
No, that is the
Lapsed
second.
notification.
Then beyond it.
We have filed objections also, my lord. It's covered by the judgment of this honorable.
12th June.
Which judgment?
I have annexed.
That is lapsed totally out of mood. Wrong
can-
judgments are being
If it has
cited.
waited for 5 years, it can wait for 5 weeks further.
Please, ma'am.
Please make a submission.
This is number 25, Mr. Subramanya Bhatt, yeah.
I represent the petitioner council may be called after vacation. My lord, the matter is pertaining to the validity of an act. It may require a little consideration. Yes.
19th.
Obliged, 19 June. Number 26, Mr. Muralidhar Rao, 14%.
Appearing for the first respondent.
Respondent number 3 in this matter.
Morning, Your Honor.
Respondent number 2, my lord.
The respondents appear not to have given their responses yet, Your Honor. Now it's almost approaching 3 years. Meanwhile, just yesterday, before coming here, I collected details from the manager of my complex of 130 apartments. We are consuming something like 800 liters of diesel in the last 6 months. And extrapolating across the city, that will work out to something like 11 million liters of diesel, which is being consumed. You know, it is like from, say from Silk Boat to Attibele, 11,000 tankers of diesel being consumed by the city, just in the residential sector. And you are well aware, Your Honor, that there are cities in the country where you don't require a single liter of diesel for this purpose. Even now, this court may be running on diesel genset. That is the situation in this city, which is supposed to be the tech capital of the country. It's a very pitiable situation, and the respondents are just going on delaying the matter, and the citizens are facing lots of hardships. And simultaneously, the tariffs over the last 3 years, have gone up by
I appear for
30%.
KERC, my lords. I appear for KERC, respondent number 2.
Who is the answering respondent?
I appear
Let's-
for BESCOM in this matter.
Have you filed the statement of objections?
Place it on record. Whatever steps that we have taken for development of the infrastructure, I'll place it on record.
Let's one more submission, my lords. On the last date of the hearing, I was ordered to, notice was ordered against KERC. Copy is not served, my lords. Petition copy is not served.
You should have called him saying, give one copy. For that also we need order, all right. Give one copy of that.
I can
petition.
give it right away. I don't know what was the problem.
Give. Now give it.
Your
No,
Honor,
no.
it's been 3 years almost.
Not 3
They are-
years, please.
Okay,
Not 3
approaching.
years. Kindly see in September 2022 you had filed. Again, you are saying, because first time you said 3 years.
No,
we are quite
approaching
hard.
3 years, Your Honor.
Don't
Yeah.
say- Don't say that.
Yeah.
Therefore,
No,
give copy
I
to
mean,
him.
also, yes, I will give that. They have increased tariff by 30% in the last,
Right,
30 to
right,
40% over the last
Reply not.
3 years.
Where is your reply?
I'll file it.
Your reply is there.
My lords, I'll just take the copy and I'll verify.
Neither of them.
You said you have filed the reply.
I will file it. I will place it.
You will file. How many years you want? It's a PIL.
In 2 weeks, sir.
Counsels for the respondents wants to file their reply.
Anyway, have it before the
Petition is
court
of the year
closes.
2022. Therefore, no further time can be granted for reply except up to 10th of June, put upon 11th June.
11th June.
11th June, let them file reply.
11?
Give copy, 11th of June. June.
11th June.
Yes.
Thank you, Your Honor.
Please share a copy of the petition.
I will do that.
Yes.
Number 27, to Srinivas K.
In this matter, Lord, I pray for some time to file a statement of objection.
20th June.
Number 28.
The
Velan Chidanandaya.
petitioner was granted the license for number C. Page 36, Lord.
May I request, Lord, this may be called along with 9037 of 2022 because we have cancelled the license in this matter. That has been challenged in 9037 of 22.
Same petitioner.
Same petition.
Lord, it is only the extension, Lord. The reason is, Lord, that is.
The cancellation itself was challenged.
The cancellation you have challenged. Same
That,
petitioner.
Lord, that this honorable court granted an
It is
interim
given
order
in the-
against that, they took up the matter.
Date
Supreme
is not
Court-
given.
Supreme Court rejected
And
the,
along with SC
9037 of
2024, which is connected petition, on 20th June.
Number 29. Sabha Sultana.
That in this matter, there's a direction to consider their prayer, representation in accordance with the notification. Last may kindly see page number 48. There was an earlier judgment wherein Lord respondents are directed to consider the petitioner request in accordance with the notification to be issued pursuant to 33rd ESZ, the expert committee meeting and pass appropriate order in accordance with law. Lord, we have not taken any decision, Lord, sometime may be granted. Lord will pass an order.
The light of Pedda Reddy judgment.
Not Pedda Reddy.
Come to page 79.
The Guru Reddy is the petitioner hearing.
That's what, the decision in terms of that decision, he may be petitioner. In terms of this decision, you have to take the decision now.
Lord, in this petition also is a petition.
Correct.
In this petition.
In support of the prayer now in this petition.
Please,
He is banking upon early 2007 decision.
Yes, yes.
Within what period you want to take the decision?
Lord, within a period of 12 weeks. Lord.
12 weeks.
Yes.
We can dispose of the.
Dispose.
He's saying within 12 weeks, they will take a decision in the matter.
Lord, can I just submit, Lord? My apologies, I'm a little late. Lord, pursuant to this finalization of this ECZ, Lord, pursuant to this finalization of the EZZ, they have now categorized it as a eco-sensitive zone, the area. But neighboring mining, quarrying leases are still continuing.
No, that is no answer.
Please, Lord.
That is no answer. It is like saying that the other thief is not arrested, therefore
No,
I should
I'm-
not.
I'm not
be.
asking to
Apex
give-
court said,
Yes,
on your own, you have to establish your right.
but all I'm asking, kindly see my second prayer. Give me anywhere else,
Any other,
any other. That's all I'm asking.
at least consider that one.
Consider to give any other.
We are directed to consider in respect, Lord, as per para 20 of the order.
But you are not considered.
We are going to consider.
How, this is a very bald assurance of the citizen to the.
Lord, within a time-bound manner, Lord, we assure this court, Lord.
Lord, that consideration,
considering
as
the-
my lords are also Lord opining that if it is already declared as as eco-sensitive zone, they cannot possibly give me. Lordship had asked him to file a reply on the last.
Please, a copy of the. We can keep this so that he can come out. He will consider. We can take it.
So you are supposed to consider in accordance with notification.
Lord, can I request my lords to kindly see annexure G for a moment?
Annexure
Annexure G,
page.
page 93.
Corrigendum.
Please, ma'am. There's a corrigendum issued
Yes.
to regularize the area that falls outside
Date ಕೊಟ್ಟಿದ್ದಾರೆ.
June,
ಕೊಟ್ಟಿಲ್ಲ.
21st June.
Which date will be convenient to you?
Minutes, I wonder because next week is the last week for closing. I pray, subject to your lordship's board and pressure, would it be Tuesday or Thursday? Too much of a thing to ask for, but I need to.
Choose
Could
your
it be
date.
next week, minutes?
Your own date you choose.
From the calendar.
I understand.
We
Minutes.
make always
Could it
give
be soon
prayers.
after reopening, minutes? Because my fear is that, minutes, your lordship's
दोबारा चला गया.
I would like to come back and be here.
You can only smile.
Indeed, minutes. Great.
Seal number 30 adjourned to 5th of June, sir. Number 31, Mr. Gurumurthy M.
Let's consider 31.17. Matter arises out of not proceedings in the DRT. The appellant blood is the mortgage.
I'll make one request. But 31.1 is depending upon the decision on 30. The reason is it is already reached finality up to Honorable Supreme Court. If your lordships comes to the conclusion that this subject has already been concluded, 31.1, nothing, I mean, it doesn't survive for consideration, is mere sufficient.
30. How 30 is relatable to this?
31,
31, fate of 31 depends upon 31.1.
But both, but 31 is by another respondent in the writ petition. 31.1 is by yet another respondent, not the. But the only request my lord is they had fixed an auction, my lord, which is on 25th. 25th, my lord, is
The confirmation period is, what is the confirmation period?
24th is the my lord, auction date. But subject to the result of this, my lord, we will go for auction. But or else, my lord, shall I make one more request?
But at least if they do not confirm, my lord, till
My lord,
next
what-
date, whenever.
Shall I make one?
But if we make that order, the auction will not fetch. This is what the apex court has said.
Yes.
Auction will not, nobody will.
Yes, my lord, that nobody will
That's
come
another
because
problem.
it is a subject to the, otherwise, my lord, let them do one thing, my lord.
Only
We
difficult
have
one is I am
fixed
also
a
a
reserve-
mortgagee in that sense, my lord. I am also in that.
But reserve price,
same,
what we have fixed is 15.10. And my lord, one next bid is 15.15. That's what also, if they are ready, earlier, my lord, there was a direction to deposit 65 crores. Now, if the valuation fixed is 51.15. If they are ready to deposit that amount, your lordship can decide it on merit. Suppose if they want to purchase, we'll leave it to them.
You mean to say they should deposit 51 plus?
Yes, 51.
And you will not undertake auction at
You
all?
will not take a.
And the matter will be heard and then
Yes,
decide.
yes, yes.
It's your bid amount
But
is
I'm-
51
And
crores?
so far as I am concerned, my lord, I am also the mortgagee of the property, my lord. I also lent on the property.
No,
The whole
what was
issue-
your bid?
But I have not, my lord, bid
It
into
has
the.
not bid.
I am a
Let
mortgagee,
the-
my lord. I am holding the title deeds.
Which is the highest bid? In the two bids were there perhaps.
No, no, my lord, they, no, it had not taken place. Now, what happened was, the property was mortgaged, I mean, this was an identified property by the company. The property was I mean, the injunction was granted. Despite an injunction, one of the directors, his
So
personal.
what you are saying is the secured price itself is so much.
Yes, ma'am.
But in
But
fact, I'm
reserve
told, my
price
lord,
itself is
earlier auctions, my lord,
15.10
nobody had
valuation.
bid. And auctions, my lord, sale proclamations did not go through. My lord, insofar as I am concerned, my lord, I am in the position of a mortgagee myself. And my lord, the recovery officer, my lord, of the DRT held in my favor, my lord, saying that, my lord, they cannot proceed against this property.
You are a mortgagee.
I am a mortgagee, my lord.
What will happen to the mortgagee?
My lord, my rights, my lord, if it is sold, my lord, I will be affected, my lord.
Read section
60.
Mortgage essay. Sir,
please.
It's a Tagore's law lecture on law of mortgages.
Please.
It says, where the property is held by the mortgagee and that property is auctioned, what is auctioned is the equity of redemption alone.
Please.
Therefore, your rights will remain intact. That's the law.
The difficulty, my lord, is Leonard single judge, my lord, has now said, by virtue of the order, that, my lord, my mortgage is void. Therefore, my lord, I will be affected by the sale.
It's said like that.
Yes, please, my lord. That's the difficulty, my lord, which I am
By
put through.
auctioning.
My lord, the reason is, the mortgager had no title at all. What
That is
mortgager
the
has done is, my lord, proper company has availed loan. The loan, my lord, amount, the DRT has issued certificate for 45 crores, and then, my lord, about 10 years back. Then, my lord, one of the director, who is a
If I can
guarantor,
narrate the
my lord,
facts,
he
my
has-
lord, if I can narrate briefly the facts, my lord. My lord, this property, my lord, was not the subject of mortgage in favor of the bank. Bank, my lord, had filed a case, my lord, the DRT on the basis of a guarantee given. This
Where
property
is
was,
your mortgage deed?
but mortgage is not, my lord, it's not, it's a deposit by title deeds, my lord. There's
It's
no
a
registered.
equitable mortgage.
Equitable mortgage by deposit title deeds. That's not in dispute. What, my lord, the bank claims
That
is.
itself is in dispute.
Yes, my
No,
lord.
It's dispute.
Yes, my lord, the question is, it is a clear case of manipulation by the two companies along with the debtors to deprive the right of the bank.
All right, where is your equitable mortgage
The sale deeds are-
instrument?
Lord, I can produce it. But there's no
Do that.
difficulty.
Give that copy. Show us. It's not some Ramappa giving
No, no, in fact,
mortgage of his land to Bhimappa or Canara Bank. It's a property worth crores.
Lord, this
Show
is
us,
a
prima
resident-
facie.
it's a residential property, my lord.
Okay.
No difficulty, my lord. We can.
We are entitled to raise our presumptions under 114 of the Evidence Act. It's not a 10 bigha land.
My lord, if I may
in
just briefly give the facts, my lord.
Therefore, if it is close together, property worth close together, you are entitled to is another thing. But there are such judgments where worth of the property is very high. It can be presumed by the court that there is no mortgage, notwithstanding that you hold custody of the documents of title,
Insofar as
Such judgment.
formation of mortgage, my lord, there is no requirement of a registered deed of.
That's all right. That's
my
not
lord,
to everybody.
It's not
We
part of
are
the
asking,
records
where
before
is
the lordship
your-
right now, my lord. We'll place it
Where is
before the
your instrument where
Well,
under
it's-
you got equitable mortgage?
lord. As of now, my lord, it's not part of the record, my lord. I'll place it before the lordship because my lord,
Not produced before the
the recovery,
learned
no, no, recovery, there was no dispute about it. The recovery officer also not held. My lord, if I may just narrate the facts, my lord. Recovery officer,
My lord, the thrice, my lord, thrice.
I can play.
It will be subject to, it will be list pendants.
My lord, may I just request, my lord, at least the confirmation could be, my lord, till the next day because recovery officer.
Once we do that, they will not, it will not fetch. See,
My lord,
what-
let me just, my lord, place two aspects. My lord, the recovery officer, my lord, in my case, held in my favor. Then, my lord, they filed an appeal before the DRT.
We are asking you, where is the instrument of equitable mortgage? You are not able to give it.
As of now, my lord, because there was no dispute.
No, why?
Even
We were before the single judge.
It was not in dispute, my lord.
Where you have, that's not the point.
But we can produce it before the lordship. There's no difficulty in producing such title deeds because it's not in issue. They have but if lordship has it next week, we can.
Very same lord, recovery officer. But very strangely, lord, the very same recovery officer thrice held that the mortgage is invalid and he has not got any title because of the injunction order. And very same recovery officer says, lord, he has this property cannot be sold. Very strange order was passed.
Lord, they filed an appeal before the DRT. That appeal was beyond time.
Anyway, even accepting your contention, what they will be auctioning will be equity of redemption and nothing beyond that. If you succeed, you will get it protected.
Difficulty, my lord, is now the single judge by his order, my lord.
That's what you said, that therefore you are in an appeal now.
Yes, ma'am.
That will be subject to, therefore, entire bone of contention would be equity of redemption, nothing beyond that.
Subject, my lord, of course, the learned single judge's order, my lord, if it is set aside, then of course, my lord.
That we will examine. If you succeed also, then your case, maximum that would happen is you would fit into doctrine of equity of redemption.
Insofar as
Beyond that.
I am concerned, my lord, I have equity of redemption.
Auction notice is, have you stated about the
Yes, sir,
litigation?
produce the very.
Have you stated about the litigation?
About this litigation.
No,
about
it
this
has not been
litigation?
stated because
They should tell
This
them.
is a corrigendum and.
Tell that matter is being
if that-
litigated.
what
Otherwise,
I-
it will be, as my lord has filed,
That
defrauding person who wants to buy the property. He should not buy the litigation.
He must be aware about the pendency.
Pendency, let him know.
That's all. We are not passing any order in that. way.
That's, but the problem is, but there is in clause 10, this is what.
No, it does, it only vaguely says.
Pending
it's a
litigation,
standard format. Huh?
it is mentioned, sorry, I'm sorry.
In
It is
your,
mentioned, yes. The intended bidder participates are advised to contact, so Jayalakshmi, Chief Manager, SS, so and so, before the date of auction sale, for details of terms and conditions queries, knowing about the pending litigations.
No, you should
guidance,
say, that.
inspection.
It's a very vague order.
That is general.
They're not mentioned there.
You have to put the things in the.
But the problem is, once we
Client wants to
mention,
say something, ask. It's mentioned also. WP mentioned also.
Then it is all right. Then it is all right. You show us that it is.
sorry.
No, no, it's all right. They're entitled to tell. Otherwise, we will not know. That's her anxiety.
Page 14, my lord.
14, they were mentioned.
At the, after the schedule, my lord, in for small print, my lord, it's mentioned writ appeal is
So
pending,
that's
that's all.
all.
It's
Those
mentioned.
Yes, it's mentioned in the last page, sorry, it's mentioned.
Thank you.
But you actually may say it is subject to the, so it may not.
No, they have said that.
We have already
They
stated.
did not say that. Once we make order,
They only said, no, it's not that is pending. Lordship may, since the lordship has said, my lord, it is subject to the outcome.
Tender
They should
to-
not claim equities, my lord, tomorrow.
Tender to 20th June. It was stated by learned counsel, senior counsel, Mr. Sonso, to the bank that in the auction notice, the pendency of the present writ appeal is specifically mentioned.
petition.
Writ petition.
Writ petition is specifically
I
mentioned.
request, my lord, your lordship says, subject to outcome.
This is order. You can show.
My lord, in our
There in main intent,
my lord,
but-
in the sale proclamation, one of the writ appeal is mentioned, but in our writ appeal is not mentioned. In the sale proclamation, they have mentioned only one writ appeal.
That way, it is pending, it is pending. We can say it appeal is also pending. We can say that in for yes.
So what did you? Send out to 20th June, learned senior counsel of this bench stated to point out to the court that the auction notice contains the specific information about the pendency of the writ petition before this.
This writ appeal itself mentioned.
From which this appeal arises.
Writ appeal, yes.
Okay. Yes, we have said that.
So indirectly, what does it mean?
Now the auction will not take place because they will publish this. Nobody will come to take the litigated property.
Number 32. The MB Chandrachud.
Appearing for appellant, my lord. Kindly pass over, ma'am. Kindly pass over, ma'am.
Pass over.
Lord, in this.
Interim order is there.
Yes, my lord.
So let enjoy it. Enjoy the interim order.
After vacation.
24th of June.
Obliged.
Number 33. G.A. Srikantegoda.
Appear for appellant. In this case, the order, the grant made in favor of petitioner in the year 1966 has been cancelled by the deputy commissioner in the year 2014. On 25/11/2014, against that I preferred an appeal before the KAT, and KAT granted interim stay on 5/10/2015, in which Tahsildar and deputy commissioners are parties. The Tahsildar thereafterwards, even after knowing the interim order, by his order dated 25/1/2017, transferred this very same land to the KIDB in violation of the interim order. And even in the said order also he mentioned the order, the operation of the interim stay which is granted by the KAT. Against that, I preferred an application before the very same tribunal, requesting the tribunal to say that the Tahsildar, knowing the interim order very well, has violated in transferring without even obtaining leave of the court.
All are now this. No time to finally.
After vacation.
That is the only.
Interim order may kindly be.
It will be continued.
Yes. Much, please.
24. The date may be fixed, man. 24th June. Number 34. Raghavendra G. Gayatri.
I am supporting the appellant's lord. I am respondent number 5 to 12. The
Gurraj was direct.
Sorry, I am paying for the appellant.
Promotion can wait. Promotion can wait.
Have it after vacation.
I'll file the objections, Lord, if permitted.
File it.
But I represent respondents 1 to 3.
May I not make one request, Lord? Let no prescriptive action be taken because.
We will not file any, we have not initiated any proceeding.
The KSLSA, Lord, should not take any action, Lord, to promote these because the entire.
Will
rights will be
always,
subjugated.
promotion can always be.
Not a, more or less, it is a consent order. Not, that will not happen.
Our promotions will be at jeopardy, Lord, that's all.
After vacation.
Immediate date.
Date may be-
25th of June.
My name may be shown in the cost, I think, Lord, I'm for 5.
Send out to 25th of June, name of learned counsel, Mr.
See that
Swanson,
to be
shall be
sure.
indicated.
5 to 12.
He
5 to 12.
Yes,
is appearing on behalf of this one, 5 to 12.
objections are also filed.
December 35.
Chip, paying for the respondents as well. Chip, we are led by senior counsel in this matter. Is on his legs in court all 23 or Chip.
The appellant is challenging the order of the learned.
Chip, may I kindly request for a fast order?
Senior advocate after vacation.
Then after vacation, senior is here. Always.
Thing is that, my lord, postdoc in January, no time limit and will fix, and he's sitting with that construction, he may occupy the property.
Let us see, let us see.
On that day, 21st.
Which one? December 36, to Vinayak Abhi.
Your Honor, I am appearing on behalf of petitioner. My senior has been held up in Court Hall 3.
Then beyond vacation.
Right.
37, 38 are urgent. Seal number 39. Mr. Kumar JC. 38 for other bench.
Order passed by this court on the last occasion, 4/3/23 asking the respondent to collect some rent and deposit the remainder. That has not been complied. Your lordship's direction has not been complied. And sure. This was a senior citizen's matter.
38.
38, 38. I could just remind my lordship, your lordships had passed an order directing that the son should.
No, because my order it was. Me, not before me. Not before me.
I know that. There is
Therefore, we have told.
There's
to
an
post
interim
it before-
direction which is not being complied.
Where we said it will go before the other bench. My lord has
I
said.
only request this, can a date be fixed in this week? Because
And it will go, it will come.
By protocol,
we
it
don't
comes.
have it.
It will happen.
It's a means of
should-
livelihood. I'm only requesting a date. be
One of the,
I understand, I understand.
one of us is not taking of the matter.
I know that, I know that.
Then we
Only a
can't
date.
take, even can't fix the date also.
Can it be Tuesday at least?
No, we cannot fix a date because it has to go on the administrative side for getting it posted before the other bench.
Number
There was a
39.
problem of livelihood, my lord. That is why I had to mention. Anyway.
Number 39.
Complaint.
Kumar JC.
This matter, 4 weeks time may be granted, but part of the complaints is over. It will be done, but
Rest of the things you will do, yes. After vacation.
19th June.
My lord, date may be
19 June.
96.
published.
Number 40. Raghugola Kumbigi.
Appearing for complaint. Raised for 1 week time, my lord. Raised for 1 week time. My senior is held up.
20th June.
After vacation. my lord.
After.
Number 41. Mr. Devraj case.
The order of the single judge is insofar as a construction put up on a civic amenity site by the BBMP. Not the single judge has directed for the construction to be demolished and to be handed over to the complainant, but this has not been complied with till date.
May I request? Lord, this is order of.
After vacation, you can.
Yes, my lord, only position is within 24 years.
Within
my
five weeks, nothing is done.
No, if they have filed, I don't have a school to operate.
Earlier, 12.
My lord,
12/6.
Great.
This is number 42. To Marti GB.
Await service.
Service is awaited 24th of June.
Number 43.
Number 1, my lord. May I seek for the
Representing
matter to be
the
had after
second
vacation?
accused in the case.
I don't know what the contempt is all about. There's no contempt. No, my lord, the urgency was that we had filed an application.
Absolutely none, my lord.
Okay.
District judge has handed over site to my lord, handed
Is
over
the
charge to
contempt?
us.
How can the contempt be a contempt?
Senior counsel was in fact engaged in the matter. If the matter
How
is
was-
being taken up on merits, may I seek for a date to be
Please
fixed
have a
on
look at
that
Malad.
day?
What is the contempt that they are alleging?
8:59.
Yes,
So there is no direction.
yes.
In fact, matter is also pending before the apex court.
That is a
Yes.
different
In fact,
one.
Malad,
Malad.
the,
There is only with
Why
regard
this
to the
matter?
appointment of administrator.
Correct.
Malad,
Why this matter?
Malad, the order, we are not before the Honorable Supreme Court, Malad. We have not filed the appeal. Malad, may I just point out one paragraph, Malad, of which
Yes.
the order is violated. Paragraph number 30, Malad, which is available at page number 58 of the petition.
The requirement is only till a necessary alter. Where
Alternate
is the
amendment is
contempt?
up, and Malad, a new president is appointed.
Well,
None of this was done, Malad. The,
that is, that now matter is before the apex court.
The
Apex
Honorable
court
Apex.
directed formation of the committee. In terms of that order, committee is formed
Please, Malad.
and the particular Swamiji took
Yes, ma'am.
charge of all these things.
There
Where
is a
the
second
contempt?
accused. There is a second accused.
Hello, not only that, the counsel for the complainant could not dispute the factum about the pendency of special leave petition before the
May I request
Honorable
for it to
Supreme
be
Court
had?
against the very judgment and order brought under the contempt jurisdiction. Even otherwise, no directions are found in the order which could be subjected to court of contempt. Full stop. Dismissed.
Please.
Please.
Number 44.
Lord,
Waiting for
I have
respondent
paid
number
for
5.
Number 3 and
1 and 2.
Praying time to file an affidavit. Praying time to file the compliance affidavit.
Complaints.
Yes, my lords.
You will report complaints on the next date of hearing.
Yes, my lords.
My lord, I had made a submission on the last date of hearing that I would comply with the order dated 10/1/2020. My lord, I apologize, my lord, and a compliance affidavit has been filed on 17/2/2020 and thereafter on 4/1/2021.
Already filed.
Yes, my lord, I seek for some more time to report.
25th of June.
of June.
Obliged.
Great. Number 45. Mr. Deepak
Respondent,
Bhaskar.
my lords.
Appearing for the petitioner in this matter, your lords.
Statement of
a
objections
final
has been served.
What is this PIL of 2020?
My lords, there are many commercial establishments that have been mushrooming in HAL third stage, wherein the
Commercial
width of the road-
establishments.
Yes, width of the road is lesser than 40 feet in certain places.
Width of the road we can't go into. Only recently you delivered.
It is
With the order alignment, layout,
Things are left
where it
to.
should pass, left to the executive. Let us see your relief.
May be permitted to file the statement of objections.
Have you
Yes,
filed
sir,
the
wait,
statement
wait.
of objections?
Yes.
Wait, let us see
Please.
whether the case goes to that level.
Investigation to complaints raised by petitioners in respect of new all commercial establishment operating. Road or commercial establishment, what?
Road also.
Road also. Before then.
Yes, we have taken that view already.
So we'll say that go before the competent authority.
Before the Lokayukta, we have held into
Lokayukta
judgments.
also there.
Yes.
So go
We
be,
held
that is the best. Yes.
Comes under the
Rashma,
complaint
appearing on
definition.
behalf of the arguing counsel, our final arguments were to be advanced in this matter. So, kindly see, our final arguments were to be advanced in this matter.
Pardon?
Final arguments were to be made in this matter. So I seek a date.
Well, senior is always welcome. You are also equally welcome.
Sir, we are asking you, why you cannot raise this matter before the Honorable Lokayukta under the Lokayukta Act 1984? In 2-3 judgments we have held that way. All these grievances can be raised before the Honorable Lokayukta. The statutory remedy is provided there.
My sincere apologies, Your Lordship. I have limited knowledge on this. I'm appearing on behalf of my senior. A date may be granted.
Section. Section to the relation to public service. All of it related to such action shall be construed accordingly. This action falls into one of the views. Two decisions. Administration also. The action is related to maladministration. We have taken that view in 2 judgments. We have taken, Mr. Court Officer, I have written 2 orders. We have written 2 orders where
sir.
they can go before the Lokayukta.
Not today, but search out. Search out those.
Let's search them and tell, please, sir.
After break.
After session.
5th of June.
Courts cannot run a race of opinion with the executive. This is how we have structured that judgment.
Forty-six urgents, number 47. The Prithvi Odier.
6 weeks condemnation, my lord. Furnishing of PF, my lord.
Process fee.
Two weeks. Number 48.
Await service.
I'm appearing on the
Await service.
petition.
Service to be
Await service, your lordship, and also in the cost title, your lordship, this
Respond number 2 to 4.
2 to 4 have been served. The urgency in this matter, your lordship, is that it's the summer holidays, your lordship, where everyone would opt for last date of hearing, your lordship asked what's the urgency. I had to plead that it's the summer vacation. Everyone opt for all these cold drinks and everything, your lordship. I press on the interim prayer, your lordship. Page number 18. And also page number 36, your lordship, Annexure B1. This is the environment it's been manufactured, your lordship. There's a huge drainage way and it's an old dilapidated building, and near it itself is where the entire garbage is disposed of the locality. And the we press on mainly the unhygienic and the contamination around it, your lordship.
Objections you have to file.
My lords, a short accommodation may be given. my lords. I'll be
But
filing
in
by
the
next
meanwhile,
week.
summer will come and go.
By
Winter
next week, I will
begins.
file the
Rainy season
objections.
begins.
And-
Huh?
By next week, my lords. 1 week time is sufficient.
I've already served it on April 1st, your lordship.
Go if you're urgent, urgency. Go before the authorities and seek the action in accordance.
We've even contacted the authorities, each one of them, even the FSSAI, the BBMP officers, each one of them through call and personally, your lordship, none of them have taken an action with regard to it.
31st May.
Number 49.
Next week. Next week,
Siddhartha
Your
BA,
Lordship.
Week thereafter,
Next week, Your Lordship.
next week.
49.
Hearing for the appellant, my lord, seeking for a short adjournment, my lord, which you notice to R1 to R.
After vacation.
Much obliged.
Number 50. Sanjeev BL.
Matter. On the last occasion, my lord heard this matter.
Heard, earlier heard.
Yeah, as regarding the charge sheet, my lord, whether the charge sheet was issued as against the minor charges, my lord. Page 34. Page 36 is the English translated charge sheet.
So why penalty is set aside?
Penalty is,
Because of that accident. Finding in the criminal case.
entry model you have sought for?
Yes, entry model.
Still admitted mistake. Or learned.
Malad, the minor
Evidently not sustainable.
Would have allowed now only, but we will hear you also. Contrary to 3 judgments of the apex court.
Please, Malad,
I also
the
enclosed
minor
the latest
punishment has been imposed, Malad, without holding inquiry, Malad.
There are 3 judgments.
Yes.
Therefore, anyway, we'll look.
The latest Supreme Court judgment also I have.
This will stay.
Yes.
Or learned advocate, Mr. What is your good name?
50.
Sanjeev BL for the Karnataka State
Panel Council.
Road Transport Corporation, does the appellant herein, learned advocate so and so for the respondent. The challenge is directed against judgment and order dated 16th June 21 of learned single judge, whereby learned single judge has issued the following direction, interfering with the minor penalty imposed on the workman. Then quote the order part, operative part. Full stop. Appeal is admitted. Full stop. The directions contained in subparagraph 3 above shall remain in abeyance, and the appellant shall not be obliged to act upon the directions.
51 urgent, Silamba 52.
My lord, I am appearing for appellant Timara. My lord.
Here for respond number 3, my lord.
52, my lord, I undertake to appear for respondent 1 and 2, my lord, Karnataka State Law University.
52, yes.
I'll file my vakalat.
My lord, I am appearing for the appellant here. My lord.
After vacation.
Please,
You are appearing for
1 and 2, my lord.
1 and 2.
Please,
My lord, I appear for respondent number 3.
Lord, I have to file my vakalat, my lord. My name may be shown.
This will go after. 24.
Silamba 53 urgent, Silamba 54.
appearing for respondent number 1.
But I shared the copy to the council on record, my lord.
You for this thing. you for
Waiting service, sir.
Awaiting service, my lord. I'll.
Respondent number 225, my lord, I will take.
Secretary.
Please, ma'am. I will take notice, my lord, respondent number 225.
You appear for second respondent.
Please, 225, ma'am.
Application.
Any date, maybe.
Which date do you want?
Which date you want?
First week, any date.
First week, 11th of.
Number 57.
No, it's not. 57.
is on your.
56.
High security registration.
56.
Yes.
56. If I had done number 56.
May it please, Your Lordship. This matter, my lords, I am in 56.3. Lordships may kindly take those papers.
Either you postpone the vacation or you postpone the matter. Only two.
Oh, my lords, I have a, the lordships had given us a specific date. Lords, if the hearing of the appeal is deferred, my lords, my appeal will be infructuous because this scheme is being implemented in the teeth of Rule 50. Therefore, I would request your lordships, please, my lords, give me some time to make my submission.
What is it?
Lordships. My lords, the petitioners' appellants are all high security number plates. Lords, the appellants, who are the writ petitioners, are all manufacturers, lords, known as license plate manufacturers.
No, this is a final order.
It's an
Interim order.
Interim order, refusing, my lords, to stay the notification, but also calling upon the government to work out a mechanism to facilitate the participation of these petitioners. Your lordships have taken note of that part of the order previously and had adjourned the matter, my lords, without passing any interim order on the score that the state may come up with some, my lords, mechanism to accommodate us. At that meeting, and those minutes are before your lordships, the state, my lords, has gone, my lords, completely cold on us and said we are, my lords, going to go by the impugned notification. And they have in fact separately challenged that portion of the order before your lordships, which shows the state's intent not even to accommodate us, my lords, so as to participate in this scheme. Now, I am one of the categories, my lords, of entities under Rule 50. Before my lords see the impugned notification, kindly have a look at Rule 50 for a moment, my lords. My case rests within the language of Rule 50 of the Center Motor Vehicle Rules 1989.
State appeal is also with us now.
Yes, yes.
It's appeal. State was only agreed by that portion of the interim order, which directed us to formulate a scheme so as taxpayers could also involve. So
No, that was stayed by us.
No.
that was kept in abeyance. That was kept in abeyance. The order sheet is
That, my lords, that was in a PIL, if your lordships.
Where is the direction? B, clause B.
I'm sorry, was in the impugned.
B.
Yes, madam. Impugned order.
State.
Clause B, that's right, madam. State
Okay.
government within a period of 15 days shall finalize and publish the process that is to be followed by the vehicle manufacturers to accord approval. So, my lords, our essential grievance against this, my lords, we were essentially directed to enter into the contractual realm and direct the car manufacturers how they should approve the license plate manufacturers. So, to that extent, my lords, we were-
Now,
yes,
your
my lords.
lordships, after keeping that portion of the order in abeyance in the PIL, in these appeals, my lords made a subsequent order permitting us to go before the state to see if this scheme can be worked out. If there was a door open for us, along with, my lords, the OEMs, that is the vehicle manufacturers, who knows, my lord, the petitioners may have been satisfied. But as I submitted, the state, my lords, has taken a hard line on it. They are not willing to accommodate. Now, question is whether license plate manufacturers such as the petitioners can be excluded by the state government by a notification from partaking in the process of affixing these license plates.
No,
in
what is
respect
that,
of-
what is the dire urgency to hear today itself?
Because, my lords, the scheme is being implemented.
Let it be implemented.
Not the entire appeal
For
will be,
some time.
the entire appeal will be infructuous.
Which appeal?
This appeal, because, my lords, the notification had a cutoff date, if I'm not wrong, of March. That has been extended subsequently by the state. Now, if we come back to your lordships, my lords, in June, they are going to present a fait accompli before your lordships.
May I place the figures on record?
For whom?
I'm
Your
told,
state.
for the state, my lords, for the state.
They have also.
There are, my lords,
This party stayed in your appeal?
Yes, it is kept in abeyance.
Interim
Now,
orders in the writ appeals.
now, insofar as the submission that the appeal will become infructuous, my lords, may I just place some figures on record? There are about this entire litigation pertains to vehicles manufactured prior to 1st April 2019. So it's only for old vehicles. Approximately, my lords, there are about 2 crore such old registered four-wheelers as well as two-wheelers across the state. Now, my lords, the latest figures is only about 30 to 35 lakhs have actually been implemented. So there is a vast number of vehicles that still need to be affixed.
170 lakh
deadline-
vehicle.
And the deadline, but I asked the officials why a long deadline cannot be given. Because every time what they're doing is 2 months they're extending it. And the answer also was, in fact, I would feel very pertinent. Was the answer was this: if we give the public a deadline saying, please do it by 2025 March, everyone will sit back and say, I have 10 months to do it. So if we tell them you have 2 months to do it, at least we'll get some more numbers. So that's the only reason.
I'm
That
grateful
deadline is
to
dynamic.
my friend now that the state is conceding that they are exerting pressure, my lord, so that this scheme be implemented.
Correct.
Now, please see
In
your
the larger
lordships-
public interest.
Yes. Lords, whether in public interest, the state can favor a vehicle manufacturer at the cost of a category of persons who have obtained licenses is the question before your lordships. It's an Article 14 question and an entitlement question under Rule 50. Now, just see your lordships order, my lords, of 22/11/23. Learned additional AG submits that in WP so-and-so, which was a PIL, a statement was made that the state government was in the process of having deliberation and discussion with the stakeholders. However, some stakeholders were left uninformed of the same, that is us. In all fairness, he submits that a meeting shall be held within a week or so with notice of invitation to the appellants herein and other appellants in similar writ appeals, writ petitions, so that they can also participate in the same. He assures the court that a copy of the minutes of the meeting could also be placed. Now, at this meeting, there was no accommodation made by the state, and they revert to the impugned notification. Lords, in just what has been done by this notice,
You are saying that they will be exhausted, number will be exhausted. They are saying about 30 lakh vehicles have been
So far.
undergone this process now.
And that started in August 2023.
From August.
Notification from August till now, about 30 lakhs have been done.
Lords, firstly, this.
But what he says is, as against entire 2 lakh which you quoted,
2 crore.
we have statutory right. That cannot be diminished by your act appears to be his argument.
That's his argument, Manoj, but I take objection to that because Manoj, there is no statutory right, I believe, under Rule 50, which vests in the appellants before my lords today. And Rule 50 is very clear in its wording, Manoj. Of course, they have their right to contend that there is a statutory right, but the central government also has come on record stating that the state government is the implementing agency. The state government can opt to implement the scheme in the manner in which it wishes among the 3 options given to it. One of which is through the original car equipment manufacturer, that's the car manufacturer. That's what we have done, Manoj. And that's in fact the scheme being done even for post-1/4/2019 vehicles. So to ensure uniformity, we have opted, and of course, paramount interest is security. So instead of Manoj having license plate manufacturers authorized, now that may possibly give rise to I'm not saying for a moment that the appellants before my lords are like that, but they might give rise to certain unauthorized persons unscrupulously supplying these license plates.
I think the state is getting ahead of itself. First, kindly see Rule 50. This bogey of security is being presented before your lordships. I will demonstrate how, my lords, it has no legs to stand on. These license plate manufacturers.
That this very issue, my lords, whether these approved license plate manufacturers can actually not affix the number plates, is pending before the apex court. And there is an order, my lord, which says any challenge to this will be, my lords, before the apex court itself. Please have a look at paragraph 13, my lords, of the impugned order, if your lordships are pleased to. My learned friend can address, because ultimately, my lord, this is a scheme which is being looked at by the Honorable Supreme Court. Lords, para 13, my lord, of the impugned order. Lords, paragraph 13 of the impugned order, if your lordships have the state SLP, it is at page 35, paragraph 13.
Of which appeal?
Lords, that is state appeal, my lords, 1273. But the orders are common. So paragraph 13, your lordships may have. Yes, I'll just place that. This court is of the prima facie view that, I'm sorry, can I place it? This court is of the prima facie view that the amendment of Rule 50 of the motor vehicle rules in August 22 will have to be read in conjunction with the terms of the statutory order of 6th of December 2018, which is in challenge before the Supreme Court, that the insistence on the approval for the licensed manufacturers to supply HSRP for old vehicles may not be extraneous or beyond the requirements in law. Therefore, this court at this stage is not persuaded to opine that the petitioners have made out a case against approval by the state government for supply to HSRP to old vehicles. This court must also record the undisputed position that the Honorable Apex Court is monitoring the implementation of HSRP scheme, and it has observed that any challenge to the statutory order dated 6 December, which amongst others stipulate the license plate manufacturers must be authorized by the state government, must lie only before it and not by any other court. Now kindly have a look at, my lords, page 209.
My lords,
if my learned friend can just give me 30 seconds more.
Please go.
That's 6/12/2018.
Yes, my lord.
Which amongst other stipulate
Yes, my lord.
license, other orders also.
Yes, my lord. Now kindly have
Cognate
that.
orders also.
Yes, my lord. Lords, what had happened in 2018 is this. My lords, the regime changed. And my lords, by an executive order under that 2018 regime, my lords, the central government said that these approved license manufacturers can affix only with the approval of the state government, which is what the 2022 amendments expressly seeks to do. Now, if that substance of the matter is before the Honorable Supreme Court, I respectfully submit one of the learned single judge is absolutely right. Which your lordships will find at page 209 of this appeal. Page 209, my lord. An affidavit was filed by the union and paragraph 3.
209 of state appeal.
Yes, my lord, of the state appeal.
209 state appeal.
This is the order, my lord, which the learned single judge refers to. Lord, affidavit was placed by the learned ASG, and kindly see paragraph 3. In accordance with the said assurance and in compliance with the orders of this honorable court. I'm sorry, my lord. Yes. The Honorable Chief Justice.
Yes.
in compliance with the orders of this honorable court, the present affidavit is filed, placing on record the new amendment to the Central Motor Vehicles Rules 1989, dated 4th December, and a statutory order dated 6th December 2018, which, my lord, in substance has now been incorporated in the rule. Learned counsel appearing for some of the objectors to the notification say that they would like to challenge the validity of the notification. We make it clear that any challenge would lie only in this court and not in any other court. That's my respectful submission, Lordships may consider.
One more. That Manjit Singh Bitta's case, Supreme Court, after that Parliament was attacked, Supreme Court said no High Court shall grant an order of stay also. That also we have placed before you.
Whatever may the reason, but once this statement comes.
Yes, my lords, I'm afraid, my lord, that the honorable court is being not given the entire picture. We have not challenged, my lords, the order of 6/12/2018.
You are challenging a notification.
I am challenging a notification by the state government. 6/12/2018 is an order of the union government. I, in fact, am before your lordships arguing that it is the union government and the union government alone that has jurisdiction and legitimacy under the act to impose any condition, which it has not done. Now, this very question, in fairness, my friend should have told your lordships, from what I understand, my esteemed friend appears, my lords, for the Association of Registration Plates Manufacturers. They challenged the order of the learned single judge before the Honorable Supreme Court.
What is the central government notification?
No, I'm just coming to that. May I answer that? Page 100.
Page 104.
Before that, I want to.
Page 103, my lord, at 104.
Lords, if I could just complete one submission before your lordship see that.
No, this is with regard to your submission only. Therefore, we are interrupted.
Please come to 119, lords, kindly. Six 12/2018. This is an order, my lords, issued under section 10.
So it deals, both the notification deal with the same subject matter.
They do not. They do not.
Bound to. If they are not, then they are interactive.
My lords, the state government has usurped power. The observation of the Honorable Supreme Court is that the 6/12/2018 challenge will lie only before it. Now, please permit me to point out that the impugned order of the learned single judge
6/12.
Not just that, they challenged the order of the learned single judge before the Honorable Supreme Court on this ground. I have the SLP and the SLP was dismissed. Their very first question in the SLP is whether the writ petition to challenge the notification, and I'm placing it before your lordships, my lords. Pardon me, I have only one copy.
They have taken up the same contention before the
and the
apex court.
SLP has been dismissed. That is their first contention.
But what you say is you are not concerned with 6/12/2018 order issued by the central government. What we are injured is by the action of the state done pursuant to this order.
Done on
Not even that one.
On its own accord. I, in fact, rely on 6/12/2018.
What happened to that SLP where they had
Dismissed
advanced-
in limine. Dismissed in limine. In fact, they sought leave to withdraw. This is the order. Therefore, I can see the anxiety, my lords, of the beneficiaries they are the beneficiaries of the order of the state government. Today, the monopoly has been created in favor of a handful of these vehicle plate manufacturers who are obtaining, my lords.
The state's order which you are now impugning,
lordships,
that is relatable to which rule?
There is, in my respectful submission, no power either under the act or in the rules which authorizes the state to issue such a notification. The field is occupied under section 1093 vis-a-vis the union. And for that, my lords, to just see my prima facie entitlement, would my lords kindly see Rule 50. Form and manner of display of registration marks on motor vehicles.
Rule 50 does not assign a role to the state government at all.
My lords, a limited role.
Yes.
I'll just read to your lordships, lords. Form and manner of display of registration marks
impugned. Where is the notification? 17/8/23 and
Please,
18/8/20?
notification is at 100. Page 100 of 56.3, my lord.
In your writ appeal.
My appeal. Do permit me to show Rule 50, my lords, once your lordships have seen the notice.
My lords, at the state appeal, it's at page 85, annexure.
Now, my lords, under this notification, firstly, your lordships will see the notification does not trace itself to any statutory provision, and that's because there is none. Then a bogey is set up as regards, my lord, substandard material. When the question of substandard material does not arise as the scheme is yet to be implemented, all license plate manufacturers such as ourselves go through an exhaustive process, my lords, of technical licensing and approval by a union government certified agency. I will take your lordships to that.
Semblance of.
Now, my lords, at page 2 of this notification.
No, you mean to say that state has no competence at all?
Absolutely none.
Why that the role is assigned under Rule 50 to the state also?
Lords, please see the role under Rule 50 and kindly see if this notification even comes close to that. May I just read to your lordships the proviso to Rule 50? Form and manner of display of registration marks on motor vehicles. Then the ingredients are at 1 to 5.
Provided that.
Yes, I hope my lords the chief justice.
High security
Rule
registration
50.
plate.
Yes.
That proviso.
Yes.
There are several provisions, no?
My lords, in fact, the portion just below clause 5, the license plates with all. It does not say provided. Under clause 5, my lords, the license plates with all the above
Clause Roman 5 of Rule 50.
Yes, my lords,
The
just below
plate
that.
shall be fastened with non-removable, non-reusable
Yes.
snap lock.
Ignore that,
fitting
my lords.
system on so and so.
Please ignore that and kindly see below that.
It's a separate sentence.
Yes, the license plates. May I read to my
Yes,
lords?
with all the above
Please.
specifications and
The license plates with all the above specifications and specified registrations for a new vehicle
the license plates with all the above specifications. the
on this
specified
for a new
registration,
vehicle,
and
lordships
new
may
vehicle
ignore
shall
that. We are not concerned with new vehicles.
We are only concerned with up to 2019
Yes,
vehicles.
lords. And for existing old registered vehicles shall be issued by the registering authority, that is 1, that is the RTO, or please mark 2, vehicle manufacturers and their dealers. 3, or by the license plate manufacturers, that is
Approved-
us,
Approved
or
license
their
plate
dealers
manufacturer.
approved by the state government or union territory administration. Now, the state government has not provided approval to anyone. And that has been recorded in para 15 of the order of the learned single judge.
But word used is distinction or.
It is our case that there is no approval required as far as license plate manufacturers are concerned. And the word approval is qua dealers. And that is the view that the Kerala High Court has taken. And I will be placing that order. So in the first place, Lords.
Why there is a semicolon?
Yes.
And why the next part is put into another paragraph with a capital letter T?
This was subject matter of an amendment, Lords. Please see how it read prior to 18/8/2022. Prior to 22 at the footnote, your lordships will see it has been substituted for the words approved license plate manufacturers or their dealers. Now the approval as far as license plate manufacturers are concerned is obtained by us, Lords, under Rule 130, 120, 134 onwards.
So your whole case is you could not have been excluded.
Not have been excluded. I have a vested right here as a license plate manufacturer. Now, what the state government does is passes this notification. In fact, my lords, the state government should have gone to the Honorable Supreme Court.
One second. Let us read. Let us face the text of the new rule.
Please.
The license plates with all the above that may not be applicable. What is applicable is and for existing old registered.
Yes.
Only that much.
Yes.
The first part you do not fit into.
Yes.
For existing old registered vehicle shall be issued by a registering authority.
Please, Lord.
Or vehicle manufacturers and their dealers.
Their dealers, yes, Lord.
Or by the approved license plate manufacturers or their dealers.
Please.
You fit into?
I am an approved license plate manufacturer because the method of approval is in the next line.
There's a subsequent amendment. Your
Yes,
lordship
yes,
is
There is
possibly
amendment
reading-
also. The 2020 amendment.
Yes,
22, my lord.
after 22 it was amended.
Now, my lord, just see the next line, my lords, as to what is the approval contemplated. The Central Road Research Institute, New Delhi, which is a union government undertaking, or any agency authorized under Rule 126 shall approve the security registration as per the provisions of this rule.
Amended rule. Amended, updated rule, Sibia.
My lords, on one of the dates of hearing, my lords, I had passed on something stylized as a synopsis with the entire legislative history. If my lords takes that, right from 2001, I have culled out the provisions as they stood during the relevant points in time. That may be convenient for my
I
lords.
think, my lord, my friend
I'll
can
I
hold
will
his
not-
horses.
Just because last time.
No, it's already
it-
submitted
it-
last
It started with the attack on the parliament. That note.
No, yes, my lord, but in fact, this synopsis, just for the convenience of the court, I had culled out in a tabular format.
My lords have seen the pre-amended rule. which
Up
said
to 2020 amendment I am seeing now. Thereafter again it is amended.
18/8/22.
18/8/22.
Give an extra copy. Give an extra copy.
Approved by the state government or union territory administration. The Central Road Research Institute, New Delhi, in any agency authorized shall approve the security registration.
Which we have painstakingly obtained. This entire process of approval, Rule 126 onwards, has been obtained by all of us. Now, the state government, my lords, could at best approve a dealer, or let me assume against myself, undertake a process of approving all vehicle plate manufacturers. They don't do that. The learned single judge records in para 15 of the impugned order that none of the private players, including the beneficiaries, have any such approval.
Amended rule, chief.
I believe my lords.
It's
the
not
Honorable
there.
Chief
It's not
Justice-
there.
Yes.
In one petition, it is produced also. Amendment is produced in one of the
My
petitions.
friend says he has
No,
filed a
there is
compilation.
separately, my lords, across the
separate.
bar, I had submitted. I have one extra copy, my lords. If my lords, if the court officer could trace it, I do have one extra copy which I can share right now. ಈ ತರ ಒಂದು ಕಾಪಿ ಕೊಟ್ಟಿದೆ ಯಾವುದೋ ಒಂದು.
In fact, my lords, if the state government had to do anything, they ought to have sought the leave of the Honorable Supreme Court. Today, an effort is being made, my lords, to turn the tables on me. When their case is that the Honorable Supreme Court is seized of the matter, for them to issue willy-nilly notifications.
My lords, my copy is, I'm sorry, it's little marked for your lordship's convenience.
Please, my lords are seeing Rule 50. So there are, my lords, in all, 3 categories. One is the registering authority. One is vehicle manufacturers and their dealers, we are not concerned. Or, my lords, license plate manufacturers or their dealers approved by the state government. Now, we fall squarely under the category of license plate manufacturers who have obtained approval from the Central Road Research Institute. That position is undisputed. Now, what this notification does in the teeth of the orders in MC Mehta's case is to take it upon themselves to create a new category of individuals not recognized under.
So these notifications are under Rule 50.
50.
Now go to the Supreme Court order.
Please.
Kindly go to the Supreme Court.
Please, I'll do that.
Paragraph 3. In accordance with the said assurance.
In accordance with the said assurance, Lord, may I read the earlier part, your lordships? That this ministry, that is the union, had earlier assured this honorable court that necessary steps will be taken for the purpose of affixing color-coded stickers by carrying out suitable amendment to the central motor vehicle rules and by issuing a separate motor vehicle HSRP order 2018 so that multiplicity would be avoided in the larger public interest. That's my case, Lord. Having regard to past experience of enormous delays. In accordance with the said assurance and in compliance with the orders of this honorable court, the present affidavit is filed placing on record the new amendment to the central motor vehicle rules issued by GSR so-and-so and a statutory order dated 5/12/2018.
So GSR 1162E dated 4th December and a statutory order SO 6052E dated 6th December.
Quite so much.
Now these are necessarily relatable to Rule 50. And the notifications impugned here are stemming from Rule 50. Therefore, now go to next line of the Supreme Court.
I will, my lords, meet my lord's doubt. Learned counsel appearing for some of the objectors to the notification say.
Notifications.
Yes.
It doesn't specify notification.
My lords,
So all notifications which may stem from these amendments have to be go to
my lords,
the Supreme.
that is QA notifications issued statutorily. These are statutory notifications. 109, this is not a carte blanche or a license from the Supreme Court for every state in the country to do, my lords, as it pleases.
At least they're inextricably interwoven.
My lords,
50.
In fact, in my submission, they are not, because I rely upon the 2018 notification. And as I'm submitting, my lords, this was the ground raised by them by the before the Honorable Supreme Court.
So the same contention was raised before the Supreme Court.
Yes, but it was negatived also.
Lords, I am not aware of that SLP.
Anyway, now
Yes,
there is an order.
Yes, yes.
It might not appear. There is an order.
Yes, it's my learned friend's
SLP
client,
seems to have been
maybe.
withdrawn, but that's another.
Withdrawn means, otherwise Apex Court would have said, no, you could not have done, you should have come here only.
Yes.
But then withdrawn, then how do we know the mind of the
Order
offense?
itself. That's what.
Lords, against the, yes, sir.
Lords, in fact, if I may say so.
May I just,
If the state was to act responsibly, they cannot hide.
Then what we may say may also be right. What you say may also be
I did
right.
not go to the Supreme Court.
Supreme Court
Manoj.
is not specified.
No, I think my friend has not understood me. What I'm submitting is the state responsibly.
That contention was taken up and they did not press that contention.
That's the private
nor
party.
pressed the petition itself. They withdrew it
They
and
withdrew.
therefore it is dismissed as withdrawn.
Yes, and the,
But how we can assume on what ground these things have
that is
happened?
their very first ground in the SLP. I'm
Now
placing
the
that now.
lawyer raises a contention before the court of law
Please.
and then withdraws the contention. That doesn't prevent the court of law to uphold that contention.
That way.
Lords,
Because nothing is stated on that.
prima
Anyway, this is all loud thinking, but
I understand.
no time to go on to do all these things after vacation. Immediately on reopen.
Immediately after vacation.
Immediately
we'll
on.
fix,
Not
this
your
one.
lordships may please give me leave to move the vacation court in that case.
How vacation court will be able to take up this matter?
I have moved an application for stay. Because this is the difficulty. Perhaps, my lords, with my endeavors, your lordships have seen that
We are not going to say
that
anything.
what the state is doing, my lords, ex
Because
officio
this
is
is not
beyond,
an one-off thing.
beyond
16
50.
other states, my lord, have followed the OEM
What
model.
they are doing is
16
beyond
other
50.
states. This is not, my lord, only state
And
of Karnataka.
today, a BMW is authorizing my learned friend's client to affix number plates in a Maruti. It is an absurd situation in the state of Karnataka.
16
There
other
is no
states.
reason why a private BMW owner, except for some extraneous reason, there is no reason why a BMW or a Mercedes, my lord, should assume the role of authorizing third-party individuals or agencies to affix these number plates. When we have undergone, my lords, the rigorous process of obtaining the approval from the statutory body, we are out completely.
Notification issued by all the state. This is not a one-off thing which the state of Karnataka is doing.
Your
Lords,
version appears from the
They'll-
Kerala High Court
The
judgment.
Kerala High Court is in fact, my lords, granted a stay.
Lords,
May I submit this?
What
16 other states
I'll
are
just-
adopting what is called the OEM model. And kindly see, Mars, as recently as January 2024.
No, what is the rationale of this kind of providence?
To bring in the provision itself, my lords, was to ensure that the scheme is implemented in a seamless and uniform manner.
But
Now
how my lord's question is, how some private entity would authorize another agency to do that?
No, that's not. In fact, that is a misreading of the scheme. The scheme in effect is this: the consumer is all important. The consumer has to receive a license plate, the high security registration plate. Now, in what manner he receives it, in the most uniform and seamless manner, the state, my lords, is the implementing and executing agency. In our wisdom, my lords, in our experience, we have found that the consumer would be benefited if he has one person to go to and only one person, that is his dealer. So if, my lords, there is a Maruti, let's say Mandavi Motors, instead of asking him to go to A road or B road, please go to your Mandavi Motors. You will get your HSRP over there. Now, my lords, now the questioning the wisdom of that policy, my lords, would not.
Dealer.
Yes, my lords, the dealer, the car dealer, the car dealer.
It's
It's
a
not the
very
dealer on
serious-
the roadside. my lords.
Oh, it is a very serious matter.
Yes, my lords, extremely.
The background of this new formation of the rule is attack on the parliament.
Yes.
That is the background.
Correct, ma'am.
That we cannot divorce
Yes.
while interpreting a provision of
Absolutely
so
right,
much
ma'am.
importance.
Absolutely right, ma'am.
If that is so, my lord's question is, how is that a private agency is allowed to do this job? That will defeat not only defeating his rights, that will defeat the policy content enacted in this new rule.
I understand. Now, I'm sorry. Maybe
That way.
I understand. Ma'am. Now, may I answer this at two levels? One, my lords, that the fact that a private agency is doing it is what the rule unequivocally mandates post 1/4/2019. So it is not as if a new scheme is now being implemented. And a scheme that is working perfectly well, perfectly seamlessly for vehicles post 1/4/2019, and which the state has seen for 4 years. We have seen the experience of implementing for post 1/4/2019. We're adopting the same scheme now. That's all, my lord.
You can convince the learned vacation judge for
Vacation
urgency.
judge.
We are not going to
It requires a deeper
express any mind
consideration.
on the urgency and moving. You can move, no difficulty. Nobody prevents you to move.
Sir, my name is Gauri Shankar. I filed a PA, sir, regarding the same matter, litigation, on the issues or the same matter. Unfortunately, what happened is I combined my PL with this commission matter. I feel that it's not the right way to do because my scope of matter is totally different from what is contained in this.
Having deliberated the subject matter controversy for some time, stand over to 11th June.
Please.
So grateful. to you all.
Grateful.
Deeply obliged.
Lordships.
appear on behalf of Mr. S.H. Prashant, my lords. He's not in town, he's out of.
So yesterday, the bench was different. Justice Katti was sitting, where we passed an order requiring presence of the in contempt matter commissioner. Now we have modified it, giving option to remain present if your answer is not satisfactory through video conference also. That
Please, my lords, I'll
that
convey.
much modification so that the officer may not have to waste his time here.
Please, my lords.
It is toned down to that extent. You can say that. You can convey to your senior as well as your client.
Please, my lords, grateful.
Seal number 10, Mr. Abhijit.
My lords, I am for the petition, my lords. This is a writ of certiorari, my lord, challenging the impugned endorsement issued by respondent number 6, annexure B, my lords. Page number 32.
Page 10, paragraph 10.
Page number 32, my lords.
Go to page 10, paragraph 10. You have to answer this. Mr. Counsel.
Yes.
This is your say, but this is the reason. It falls within 10 kilometers of Kali Reserved, Kali National Park.
Yeah.
Kali Tiger Reserve.
Yes.
So that is the ground of action
So
against.
irrespective of this, annexure C, my lord.
Page 31.
Yes, my lord, page 31.
Second para.
Yes, my lord.
It says 10 kilometers.
The respondent number 6 has stated that my area falls within 10 kilometers.
He is saying that page 10, that it is not correct.
So page, according to page number 10.
It is not one of the national park tiger reserve identified by the Supreme Court in that proceedings of writ petition.
Not necessarily, my lord. Subsequent decision in
That
Godavarman case.
Is why I asked him to.
Not, list is not exhaustive.
Yes.
List is
not exhaustive. Whichever fits into that parameter, that is also covered.
Even in Godavarman's case.
Godavarman
latest-
only.
Yes, in latest order. my lord, which I
Newton's
have-
matter.
Yes, which I have produced.
Order passed by the Supreme Court.
Apex Supreme.
Yes,
Very
Last one.
that I produced.
In that interim order.
Interim order.
Deemed forest.
Deemed forest.
Yes.
My lords, annexure C, that is page number 34, maybe 35, Your Honor. Here a notification is already been issued, which states that 7 kilometer is the eco-sensitive zone of the KTR, Kali Tiger Reserve, which was earlier known as DATR, that is Dandeli Wildlife and Anshi National Park. Second last paragraph, my lords.
So this is
Third
renewal or fresh license?
So this was the first
Fresh license. It's within a distance of 10 kilometers.
Within a distance of 10 kilometers.
Within 10 kilometers.
And moreover, what is challenged is some large interdepartmental communication written by the DCF to the Deputy Director of Mines and Geology.
No order is passed pursuant to that.
No,
No order passed.
no order passed.
So based on this endorsement which has been issued, my application is already been rejected, sir.
Can't say that it is only, if it is pure intra-departmental, then 84 Karnataka Law Journal DB says not challengeable. But once it is communicated to party, morning we have considered
Yes,
the
yes,
same
yes.
aspect, na? Then it partakes some different character. That's only thing is that that forest need not be, the list is not exhaustive. Number 2, the parameters are fixed by the judgment in Godavarman series. And therefore, if it is otherwise within the parameters, then it needs to be elongated. That's your contention.
So we are dismissing it, Mr. Dismissing. Can you pass over that order?
Yes.
By Monday? Or if today, best?
Today itself, I'll.
That
Pass over to
Newton's judgment,
Court manager.
Delhi,
Delhi
where
judgment
they
as
said
well
it's
as.
a deemed forest.
This is.
There are three judgments.
Eco-sensitive. zone.
Eco-sensitive.
Whatever
judgment.
applicable.
Please.
That we can refer to. Sorry, Mr. Yes.
Number 21. KV Narasimhan.
I'm filing the RTC's plan. The order has been complied.
They have already mutated the entries also.
Yes.
Comprehensive.
The statement made by learned government advocate Mr. Mahendra, along with submission of the
RTC and mutation register.
plans,
Copies of RTC.
which includes the
RTC. RTC.
RTC. Copy of the RTC could not be disputed by.
And mutation register extract also.
Them are also
Yes,
produced.
sir. Yes.
Them are mutation register also.
Could not be disputed by learned advocate for the complainant, Mr. So and so, so and so. Also produces the copy of the mutation entry in relation.
Entry is made. The rest of the things you have to challenge.
I may be
Reservedly, but
In that view, the compliance is done. The present proceedings of contempt are liable to be closed. Accordingly, they are closed and disposed of. It is however observed and clarified that if the complainant still has any grievance about the merits of the compliance, it will be open for him to institute independent proceedings, for which this court, however, does not express any opinion on merits.
Number 79 for withdrawal.
Hearing for the complainant, I filed a memo for withdrawal.
In view of the memo of withdrawal dated, where is that?
It's dated 5/4/2024.
5/4/24. Which in earlier state says under. Last period. Green flag. However, during the pendency of the top noted contempt petition. Disposed of accordingly. The permission to withdraw the proceedings is granted, disposed of accordingly. This is.
Writ appeal for withdrawal for 80. Mr. Pawan Chandrasekhar.
Serial number 80.
Matter amicably settled between the parties, my lord.
Learned advocate Mr. So and so stated with reference to the memo of withdrawal dated 15/4/24 held by him that the dispute is settled by the parties amicably outside the court. The proceedings therefore does not survive as these parties have settled, disposed of accordingly.
So number 81. to VB Shivkumar.
Appear, please. The order has been
Appearance,
complied.
complaint.
Order is complied. They have rejected.
Challenge it.
I have to challenge it. Reserve my right to challenge it.
You are Mr. Shivkumar?
Yes, please.
Learned advocate VB Shivkumar. Clearly stated that the order is complied with, therefore this contempt application will not survive. Full stop. He have submitted that the order of compliance is against the complainant and that the complainant would opt to challenge it in independent proceedings. Such liberty is reserved. However, this court does not express any opinion on the merits of such recourse. Full stop. Flesh marks. The contempt petition is disposed of subject to above.
Number 82. Issue Baba R. Mishra.
Respondent, my lord. The respondent is present, my lord. And there is a DD, my lord. In the name of the mother, my lord, complainant of 30 lakhs.
Yes, yesterday, day before yesterday.
Please, my lord, it was 8th, matter was posted on 8th of April.
Directed to deposit.
30%
30 lakhs.
30 lakh DD.
Please.
They have brought the DD now.
Yeah, please. In the name of the mother, complainant.
The name of mother. Another 15 lakhs needs to be paid now.
The total amount is 80 lakhs, my lord.
When
75, it's a 75 lakhs, my
My
lord.
lord, interest has accrued.
30, 75, total 75.
Please, but.
Now 30 is being paid. And another 45?
35 will give you other 3 months.
3 months. Why?
Because loan is applied, this election period is going on, no one will sanction. That is after the 2nd of June only we can get the process. That is the way.
This amount may be deposited in the name of 2 children. 18, 15.
You come out with some installment.
You have to say the proposal.
Yes,
When you
sir.
are going to give that money?
3 months will go into that.
No, 3 months will not be given.
Because June 2nd is election period is over.
Are you contesting in the election?
No, no, no.
Then
no.
why
It
do
is
you
a
worry?
Period is
Vote
there.
and go.
No, 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 that is, this period is there. Can't brought the money, loan, bank people also not sanction the loan. Code of conduct is there. Code of conduct, we can't move the files.
Husband is here.
That is the main reason, Kaila. We are already applied, but he's not moving the papers.
What is your property holding?
Only one house is there.
House.
No, no,
Worth?
nothing.
Worth?
Only one house.
One house worth how many crores?
No, just 40 lakhs, 50 lakhs, my lord. His father has done it, not he. Father has done it. That.
Where is the location of the house?
House that is in Ullad, near Ullad.
Ullal.
Ullad, near.
Measurement?
30-40.
30-40. How many floors? One floor.
He is only living.
But you have to tell how you are going to make the payment within this remaining 50.
Salary loan has been applied along with the home. Both will be considered after the election is over. The bank people is told.
That doesn't convince us. Time may.
Within 3 months, we'll go into May.
But the reason
That is the
for
maximum from today.
Giving is not acceptable to us.
Reason of election doesn't convince.
What election has to do? You may say election in.
Code of conduct is there.
What?
Suppose you are dispersed now, they will give you some other election purpose or that is the thinking those people's.
Anyway, that will be over by 2nd of June. Everything will
Then
be over.
afterwards, they're going to release. At least we can.
When you pay.
Does not generate confidence.
That is there. That is why you give me at least 3 months. Before that, if possible, advance and pay the amount. Maximum 3 months is enough, my lord.
When the order was made.
Still the RP also is pending.
Please answer the question.
RP
3rd
also
of July
pending.
2023. 3rd of July 2023. There was no election at that time.
Not that time, we go for appeal. Appeal also will come for January.
All right.
January,
January.
they disclose that why should go there.
12th January 2024, it is over.
After that, we have filed the RP also.
Huh?
Immediately, I'll file the revision petition.
Huh.
While discussing the Supreme Court, they'll file the revision petition because complaint is in the employee.
All right, but then
Employee, she is
curative.
drawing 1,40,000.
That makes no sense.
That is there. That's why you are ordered, but this one we have to pay. Another 3 months, we'll get ready to pay in thereafter.
Not, you're only repeating. We don't entertain repetition.
Minor, minors.
Minor,
Minor
then who-
children.
13 years.
then mother will receive in her name.
Please,
Mother is,
mother is an employee of IBM, my lord.
Mother will receive the amount on
Yes,
behalf
my,
of.
yes, my lord.
She will receive on
1 lakh
behalf of her
40,000
mother.
is received salary.
mother is here now,
No.
not
She's
here.
not
You will
physically
receive
present.
that DD.
Please, I will receive it on behalf
Who
of
will
my
receive the
client.
DD? You will receive
I will receive it on behalf of.
towards the compliance of, toward the part compliance of directions in order dated 3rd July 23. Passed by the court, today the respondent husband has brought check,
DD sum, DD, it's a demand draft.
demand draft for rupees 30 lakhs, which is payable towards alimony to TO then TW, two children named Anchita and Abhigna, each. Full stop. In course of the proceeding, the said check, said demand draft bearing number so and so, drawn on so and so is ended over to learned counsel for the.
Drawn in whose favor?
The name of the mother, my lord, complainant.
Husband.
For the
T.R. Smith.
R. Smita.
Because you were supposed to
Complainant.
record it in the registry. So instead of that, we take it.
handed over to learned counsel for the complainants. Full stop. Although the earlier order required the accused to deposit the amount in the registry, since the check is brought in the name of
The complainant, T.R. Smith,
Complainant.
complainant. It is mother, the same may is permitted to be handed over to the counsel for the complainant, full stop. The amount represents rupees 15 lakhs each to be paid to the each of the children towards alimony, full stop. Learned counsel for the complainant takes responsibility
Please.
to pay, to hand over the amount accordingly
Please.
to the complainant. Full stop. For the rest of the amount, learned advocate for the respondent stated that the balance amount in installments will be paid as expeditiously possible, and in no case beyond 5th of June, full stop. In view of the above assurance, the proceedings are directed to be listed on 29th of May, on which date
29th of
the affidavit shall be filed by the respondent husband about making payment of rest of the amount as directed by as directed by the court. So on that day, you will to say that on this date we will pay. That will be before June 5, correct? The check, the demand draft today ended over represents amount payable to two children in the ratio of 50% each, which shall be accordingly paid, which shall be accordingly deposited by the mother in separate account of both the children.
Please.
Separate bank account of both.
Please.
'83. Shashikant Patil came.
Have complied, not complied the order.
It has been complied.
Complaint.
Learned counsel for the
I'm filing complaints.
stated that order, the directions are complied with. Full stop. The same is fortified by compliance affidavit today by learned government advocate Mahindra. In view of the compliance obtained, the proceedings are closed and disposed of.
Conversion order.
Yes.
Number 84.
For the complaint.
Mention the name of advocate for the complaint.
This matter we have
For the-
filed complaints.
No, my lord. On the last occasion, the complaints, we have filed an objection. On page 40, your lordship, there was a direction to the government to consider the refixation of pay. Kindly turn to annexure, page 40, my lord. And your lordship was directed them to pass an order on this page 40.
Page 40.
And they have not passed an order. Now they say that we have sent, it is 3 years, the order is 3 years back. Now they say that the opinion is sought. Some order should have been passed by them. That was the direction.
Not passed.
Not passed in order. Now they say that legal opinion is sought from the law department. It is a clear case of violation.
Last may kindly peruse the
Compliance affidavit.
affidavit 15/4/2024. Para 5, please. And in para 4, we say, Lord,
Page.
page 2,
The compliance.
complaints.
This amount is paid.
7,51,485 was released to the district consumer dispute redressal forum towards earned leave.
Complaints.
This is in respect of earned leave. So far as treating them on par with the judicial member is concerned, in para 5, it is stated, page number 3, Lord. 11/9/2023 of the London single judge as part in writ petition number so and so, fully treating the petitioner at par with the district judge, retired district judges. I respectfully submit that at the time of appointment of the complainant, his pay was fixed at par with district judge only. And he has drawn the salary with which is equivalent to the salary of the district judge for the whole period of 5 years for which he was appointed as president. Therefore, the question of refixing salary does not arise. But so far as SNGPC is concerned.
No, his very case was he should be placed on par with the district judge.
District judge.
So far as the salary is concerned, he has been.
Yes.
He has been. The amount, whatever now you claim to have paid, remitted 7,51,485.
Yes.
That represents what?
Towards earned leave.
Earned leave.
Yes.
That's all. Earned leave, that too partial payment. So far as refixation is concerned.
Where is the question of refixation?
No, you are not.
That order says that way. The question is.
Pending it was.
Your refixation should be to bring you on par with the district judge.
Correct.
You have been. You have already been.
No,
Therefore, again, refixing will not arise.
Your lordship may kindly pay in accordance with law that particular.
That is paid.
There is a direction. No, it is not disposed of. All India judges case from 1/1/2016, they are entitled for it.
You have been paid the salary of district judge. Do you dispute that? Ask your client to file affidavit.
We should
not go by argument like that.
No,
we are here to do justice.
This all India judges case.
Have said that.
Yes.
You are only repeating
yes.
it.
No, that in the as per that.
We are saying, he says, right from day one, you have been placed in the pay scale and the salary of the district judge. All right?
Yes.
If you dispute that, ask your client to file an affidavit. If it is false or wrong, then action will follow. And whatever
this direction
pay encashment is concerned, he says so much amount is paid now.
No, that also a part, my lord. 5 years period is also considered.
That you have
that no, I have filed objections to that.
We can't entertain all that. It's not a critical examination.
No.
It's only compliance is substantial compliance. If we accept your contention, you need to be paid more than what the district judge has been paid.
No, I am not saying that.
It goes that way. Your complaint question.
No, it was pending, my lord. That has to be paid. Even the order of this honorable court, all benefits, monetary benefits. Kindly see the annexure A order. After that, my lord, there is one more order. All monetary benefits to be paid. So as per that, all India judges case, they are entitled for the salary. All monetary benefits. They don't have to be, the right is accrued, my lord. It not be re-agitated. It's already adjudicated. And 3 years back, that order came to be passed.
We dispose it. This contempt petition was
Well,
filed.
then the contention may be left open.
Left open. Liberty.
As regards the
What contention?
second National Judicial Pay Commission.
Contention about?
Second payment under Second National Judicial Pay Commission with effect from 1/1/2016 is entitled for. That is my
Lord,
argument.
in para
He was
7,
in
it is
service.
clearly stated. In para 7, whenever we are extending SNJPC to judicial
He
He
member.
also will be.
Yes,
given that.
that is made clear in para 7. Para 7 of the affidavit. I further respectfully submit that as soon as the reply is received from the legal department, the representation on the said issue will be considered by virtue of the order.
Para 7 of the affidavit.
Yes, Lord. I further respectfully submit that SNJPC pay scale is not implemented to any of the president of the District Consumer Commission, including the retired judicial officer, and hence no discrimination or disparity is shown.
Subsequent and subsequently one more affidavit.
The second affidavit, 15/4/2020. Two affidavits, one is compliance, but another is 15/4.
Why, I was looking at that comparison. The present contempt petition was filed seeking compliance of directions in order dated 11/9/23, passed in writ petition number 19690/23.
And one more order, my lord. Annexure B, 15th March 2021, general direction. Annexure.
The compliance affidavit indicated that the complainant was the
Consumer dispute.
who was a chairman.
President of.
President
President of
district consumer. Was the president of the district consumer dispute redressal commission has been paid his dues in respect of leave benefit. Full stop. The affidavit accompanies copy of communication dated 19/3/24, which shows that the amount of rupees 1,51,485 has been dispersed in favor of the petitioner as the ex-president of the Consumer Dispute Redressal Commission.
7,51,000.
7,51,485.
That's also part compliance according to law. Like we noted.
Which is as stated above, towards leave, on leave, in compliance with the directions. The learned advocate for the complainant, however, raised a submission that complainant is still entitled to be paid the pay scale as per the recommendation of the Second National Judicial Pay Commission, and that the same is not paid. Full stop. Even as it could be seen that the said aspect is not part of the directions brought under the contempt petition. In the affidavit dated 15/4/24, passed by the filed by the competent authority, the said aspect is dealt with in paragraph 7, extracted below. And paragraph 7, then dot, then as soon as it starts like a yellow flame, as soon as up to produced here with page 3 and this yellow flap is kept. There be no grievance surveys for the complaint. And this was everything is closed.
Yeah. All contentions.
How is
Well,
it? What contentions?
Second national job, it's
No,
applicable.
they have said that they will
They are
pay as
saying,
soon
but
as
they
they-
are, they have to pay it has to. Here, tomorrow they may say it is only
No,
for
on
the district
affidavit,
judges.
we have stated. It's an affidavit.
All contentions of both the sides are closed. Don't write.
By 85.
This was 84.
In this case, my lord, they have issued an endorsement, my lord, in lieu of the endorsement issued by the mayor, complaint may be dropped and reserving liberty to challenge the same issue.
Filing the affidavit, the issuance of endorsement in the year 2023, man. In spite of reissuing the endorsement, they filed the complaint. Lord, within 4 days, we complied with the directions of this honorable court.
The polling station.
Yes.
You have complied with the order now.
My lord, in 2023 itself, we have issued an endorsement.
That
Now he has
complies.
filed. Yes, my lord. He has received the endorsement also.
Which is that?
My lord,
Nexus?
page number 12 is the endorsement. Page number 12 of my affidavit is the endorsement. Lord, English version starts from page number 14.
So you have shifted the polling booth to?
My lord, nearby area in that Niladri Nagar.
To
My
that
lord,
school.
he has challenged that shifting. Learned single judge has directed to us to consider his representation for reshifting those polling stations.
They reshifted.
No, my lord.
Yes.
We have rejected his claim because my lord, 4 days were left for voting in the 2023 elections. It was not possible for us at the
11th hour.
Please, my lord. Therefore, we issued the endorsement saying that it will not be considered this elections.
For
we
the
have-
next election, we will do
Please.
that. The direction was to consider.
Please, my lord.
The petitioner said, the complainant petitioner had filed a petition making grievance that the polling station to which they were attached was shifted from Doda Tugur village to Ulima Nagula village. Full stop. Taking note of the grievance, the court directed the state directed the election commission to decide the representation of petitioners. Full stop. Today, the affidavit is filed by the competent authority of the election commission to show the compliance by stating that for the reason stated in the affidavit, it was not becoming possible for the election commission to reshift the polling station for the present election. Full stop. The representation is accordingly decided, therefore the contempt of proceedings does not survive and they are closed. Parties are deleted.
Number 86, Ramatullah Kutwal.
Appearing for the petitioner, lordship. Lorships, there is some inconvenience. Arguing counsel not yet.
Inconvenience.
Yeah.
My lord, nothing survives in this writ petition, my lord.
He is on pilgrimage. He went to Mecca, your lordship, for
Make it
performing
convenient
Umrah.
after vacation.
Please, your lordship.
Make it convenient after.
My lord, it's
For vacation,
purely
my lord.
academic now, my lord. Election, he is, the respondent number 5 has been nominated.
Nothing survives for consideration at all.
Survives, your lordship.
Huh? Still survives, even after election is over, still it survives.
No, it's purely academic now.
Section 14 of Oxford. Of fact, it survives, your lordship.
What is the prayer in the writ petition?
My lord, I appear for the petitioner in connected matter, my lord. It requires hearing, my lord. Senior counsel is been engaged, my lord. It may be taken after vacation.
Origin issued by number 2. Now in this world, we are not concerned with this. Who is election officer, who is electoral officer?
That's what.
Returning officer. So you are rightly seeking time after vacation.
Please, your lordship.
This
Obliged.
Number 87, Rohit Taras.
My lord,
Lord, I appear for respondent 1 to 4. My lord, this pertains to, my lord, the notification sued with respect of a forest land, my lord.
Earlier
And the last
2020.
date of hearing,
10th of. Yes, what is this?
my lord, about 75 acres of forest land in Raichur village, my lord, has been encroached for the purpose of forming a layout. And my lord, these are the forest land under the Hyderabad Forest Act, my lord, 1326. My lord, it is continued to be a forest, my lord, under the Karnataka Forest Act of section 23 and 35, my lord. My lord, previously, my lord, the earlier act was repealed and with the same clause of in the year 1355, my lord. My lord, this honorable court directed a survey, my lord, in terms of the order dated, my lord, 5/4/21, to find out whether it's a forest land or not, my lord. And there was a committee constituted, and a report is submitted to full honorable court on 8/7/21, annexure R1, my lord. As per which, my lord, it is clearly shown it will continue to be a forest land, my lord, and there is encouragements. But may I request your lordship to the report submitted by the survey conducted by the joint survey conducted by the Revenue and Forest Department, my lord. Survey's report is on, my lord, 5/4/21, my lord. Report is on, my lord, 6/7/21. My lord, this is the report with the memo of compliance. But page number 11 in that memo of compliance, my lord, there is a report. Page number 11.
11 of?
My lord, the compliance report by the government advocate filed, Lord, on, my lord, 8/7/21. And my lord, in page number 11 of that report,
What the report says?
my lord, report says, my lord, I will read relevant portion. As per the report of the Deputy Conservator of Forest Raichur and annexed document Gazette note in copies, all said survey numbers are included in the protected forest area of Raichur village and continue to be forest area under the Karnataka Forest Act 1963. My lord, this is a report.
Where you are reading?
My lord, this is the report submitted by the government.
Government?
Yes.
In that compliance order?
Yes, sir. Yes. That page number 11 is the, in that compliance. Compliance report submitted on, my lord, 8/7/21. 8/7/21, my lord. And even this statement of objection filed by the Deputy Conservator of Forest stating that it's a forest land.
Forest land?
Yes, my lord. Even the statement of objection by the official respondents, which was filed, my lord, on
27 August.
Yes, my lord, that date, yes, 2011/21. But there are two reports.
Where in the objection statement, which paragraph they have
Lord,
said
which
this is
objection statement, my lord, paragraph 5, my lord. My lord, paragraph 4.
4.
Yes.
Of the statement of objection.
Statement of objection, paragraph 3 I will read, madam. 3 I will read. The lands, may I read, my lord? paragraph 3, my lord.
Object statement dated?
Dated, my lord,
Not 20th November 2021.
20th November 21, my lord. It was based on a survey report. Your survey report submitted there.
1 second.
Please. I read paragraph 3, my lord. And along with that, they have filed the survey report also, my lord. Statement of objection. At
This was pursuant to Hyderabad Forest Act.
yes, it's a pursuant to Hyderabad Forest Act, my lord. It was saved under the subsequent act, my lord, in a repealing act. There are, my lord, now it is a forest land under the section, under section 23 and 35 of the Karnataka Forest Act. A survey is conducted to find out recently, my lord, whether it's a forest land. A committee constituted, joint committee.
That committee also told.
Yes, yes, ma'am. That's the report, my lord, before your lordship. It's submitted on, my lord, pursuant to the court order on 8/7/21. And statement of objection, paragraph 3, my lord, it clearly states, my lord, it's a forest land. And now, my lord, they are producing one notification issued subsequently, my lord, under section purportedly and section 6 of the 1355 Act.
Any layout has come there.
Layout was formed, that was called in question, and this honorable, my lord, the Kalburgi bench, my lord, have set aside, my lord, the order, my lord, cancelling the layout form.
Cancelled on the ground?
My lord, it is not a forest land, my lord, and there is no encroachment.
It was cancelled by the Gulbarga bench on what ground?
My lord, saying that, my lord, there is no encroachment, my lord, of the forest land. There is no government encroachment. And that order has become final. May I make, before that, my lord, may I make one submission, my lord?
My lord,
In
my lord gets
1961, my lord, a proceeding was initiated, my lord, by the Forest Department. In the proceedings, my lord, these very lands were deleted from the forest land. A notification is issued deleting, my lord, these particular lands from the protected forest. A proceedings, my lord, in accordance with the, my lord, Hyderabad Act, my lord, was passed. And a gazette notification is also issued. My lord, we have made a statement, my lord, on the last occasion. Your lordship will kindly see the order dated.
No, which is that Forest Act, Hyderabad Forest Act?
Hyderabad Forest Act.
Which is that section? Which
My lord,
gives power to denotify?
Section 3 and 4 of the Hyderabad Act. Lord, we have produced the notification, Lord, annexure R4.
Act.
Lord, we have produced the act also, Lord, the entire act.
Lord, may I submit the act, my lord.
Takes time, perhaps.
It will take time. Lord, my lords wanted to know, my lord. May I request your lordship kindly see, Lord, annexure R4. Annexure R4.
But
Apply
R4.
mind after it, because this will take.
It may not, my lord, I have made a submission, my lord, on the last occasion. Your lordship directed, my lord, the government advocate to find out. My lord, they say, my lord, this is concocted. Just a minute, my lord, your lordship will kindly see. Does it appear to be a concocted document?
No,
which
we cannot. It is not that easy. Even the currency notes are concocted and we will not be able to know.
Lord,
that.
I have produced.
You have to say whether
Yes.
such a notification other day,
Yes.
that for that purpose we had given
Yes,
time to you.
yes.
If you authenticate that,
Yes, my lord.
things will fall apart.
Yes.
If you say that it's a concocted document, then further hearing would be required. Did you verify with officers?
But I did, my lord, because of these elections, I was not able to.
My lord,
My lord. the
It's not only
deputy
that, my lord, we have also produced, my lord, the proceedings of the officer conducted, which in his hand, there is a signature. We have obtained this document under the right to information. We have produced those documents also. After following that procedure, my lord, a notification is issued. My lord, gazette notification, my lord, we have produced that gazette notification also. Now they say, my lord, it is concocted. They are making the officers to rely upon a document, my lord, which was prior to, my lord, the 61 notification.
We are not
To say
making-
that, my lord, it is a forest, my lord, forest land.
Then the matter lies in a very, very narrow compass.
That's why, my lord, my lords have adjourned this matter
But they have
to
to
find out
ascertain-
from them, my lord.
You have to ascertain from your officers. If already there is a statutory notification, then unless the very notification itself is spurious,
Yes.
only that much.
Yes.
If there is a notification, then things, no further question of other considerations will not arise because already a bench comprising of how many judges?
Single judge.
Single judge.
Yes.
That is different quarter.
Lord,
I'll
we
submit
have-
your last.
we-
That
Lord, we have
notification issue
also
of section
produced, my
6 of the, section 6 of the Forest Act by a settlement officer, my lord. Kalimpur.
Forest, Hyderabad Forest.
Yes, in that only I will produce the act.
Let us see.
Prima facie, they are producing a document, it's not much.
You have to
authentic.
ascertain,
Well,
you have
Lord,
to
I
make a
will do it.
statement as to the authenticity of that notification.
Yes.
That's all.
My lords may make an observation, my lord, so
No,
that it
my
will
lord,
guide them
because
to file.
latest
Lord,
survey
I have-
report.
But I am relying upon this, my lord. Let them make a statement by them, my lord, whether it is in accordance with law, my lord, whether it is concocted. They say it is concocted. Lord, I have obtained it under the right to information. How can they say, my lord, it is concocted? Unless, my lord, they come out with some material to show that, my lord, it is concocted.
So 21st June.
21st June.
Obliged,
Lots
my
of
lord.
observation, my lord.
Not necessarily, everything is recorded now here.
Yes,
Need not be again recorded.
yes, already.
Every word will
My
reproduce.
lord, I have shown the communication which I had made with, to the deputy conservator of forest, to my learned senior, my lord.
But
Because of
something has
elections.
to happen. What he
Not
will do with your
elections.
communication?
No, my lord.
He has to authenticate or does not authenticate?
My lord, if the elections were not there, my lord, I could have forced him to come to this honorable court. But because, my lord, of the elections, I'm not able to get any of the officers.
The notification
Huh?
which is issued under
They've
the
gone
provisions
now.
of Hyderabad Forest Act, they say it is incorrect. They say we have obtained it under the RTI. Therefore, government should say whether it's a genuine notification or not.
May I submit one submission, my lord? We are not saying it is concocted. The government saying it's
State-
concocted.
statement-
Government is saying it's concocted. They have filed an affidavit, my lord, stating that it's still a forest land.
Send out to 21st June. Next, while adjourning the proceedings, it is observed that on the next date, the state government shall take a stand as to whether the
Annexure R4 dated
Subject notification. Dated
November 16. November 16,
state only.
1961. 16th November 1961.
Obliged, my lord.
Annexure R4.
What did you write? That the that whether the notification that so and so received under the Hyderabad Forest Act is genuine or concocted, as the rival claims in that regard are made before the court.
Obliged.
Obliged, my lord.
But genuine regarding exclusion, my lord, because that notification issued for under by a settlement officer for claiming under section 6, he's saying it's an exclusion notification at all.
No, other issues we will hear full. Only
Yes.
this aspect. Only this, even the effect of this notification, other things you will argue.
No, I'm not disputing that notification, my lord. Exclusion is disputed.
No, nothing.
Please,
Except we are saying that they will make it.
please,
Nothing is concluded.
please.
Number 88, Mr. Prashant Rao, party in person.
Party in person.
Yes.
Mr. Prashant Rao, party in person.
That, my lord, this was listed day before yesterday, my lord. Your lordships.
Therefore, it cannot be situated there only. Scope is taken.
Not informed.
So thank you.
Yes.
No, there is party in person. The, my lord, petition could not be proceeded with, awaiting the presence of petitioner party in person. In larger interest of justice, tender to 26th of June. Registry shall intimate the party in person about the next date of posting.
Obligement.
Party has to comply with the
Paragraph. It is to be stated at the outset that the petitioner has to comply with the rules of filing public interest petition. Then enter.
Very well.
26th June.
So, seal number 57.
Yes, some time to take steps to the unserved respondent.
Gopal BV.
Some of the respondents are not served. There is some time to take steps.
Take steps. Learned advocate
Steps to be taken.
learned advocate shall take steps regarding unserved respondents. Before the next date put up on 27th of June.
Much. File wakalat in the prosecutor.
Number 58.
For appellant in these matters.
Steps you
But
have to
so
take.
far as respondent 21 is, respondent 3 in the first matter, 21 in the second matter and 3 in the third matter is concerned. It was arrayed as a party, it's the Bar Council notes, arrayed as a party by mistake because it was deleted before the learned single judge. That's noticed in the order minutes. They were made a party by the petitioners and deleted before the learned single judge. In the appeal, we have arrayed them as a party by error. Your lordships may
Seek a
dispense with
deletion.
notice.
No, file a memo so that
Very
we
well.
can delete those names.
We'll
na?
file a memo to delete it. We'll file that over the course of the day.
After it.
Very well. Obliged. So would your lordships fix a date, minutes, because there's a remand to consider the issue all over again. Although the appropriate authority had considered the issue twice.
13 June.
Please,
13 June.
I'm grateful.
Number 59.
59. 59.
Babar Mishra. Waiting service.
Please seek a week's time in respect of taking service. Seek a week's time.
SPP or
After
Taking
it.
service.
Lord,
Respect-
Lord,
Conservative.
I have a small submission. The respondent number 2, or average age is 79 plus. They stay in a retirement home. Now, they are under a threat constantly for the last so many, almost 5-6 years. There is no fire clearance. Between the appellant and respondent number 6, a ball is being played. Even today, there is no fire clearance there, because there are certain works which have not been completed by the appellant. Even the fire department is also not in a position to give the fire clearance to them. The second thing is the respondent number 6 is stocking high density diesel, etc., without a license. So my humble prayer is a fixed date may be given immediately after the vacation, so that Meanwhile, if some relief can be given through them, I mean, I would appreciate because average age is 79, they are present in the court. That's my submission.
28, 20.
20.
Interim order may be extended, my lord. Interim order may be.
No, it's an abeyance order anyway.
Tender to 20th June. Interim order already granted, shall continue to operate till the next.
Bless you.
This is number 60, sumo to criminal contempt.
Appear as an make in this case.
This is about
Sumo to contempt.
My lords, I'm for accused, my lords. I have filed wakalat today morning, my lords. I will be granted in a week's time, my lords.
You have filed wakalat today.
Yeah, my lords.
Where is the accused?
Accused. Who was there, my lords? Morning.
It's a criminal proceeding.
My lords.
Accused has to be here, or he should make an application seeking exemption for the day.
It's 7 minutes.
My lords, kindly pass on, my lords. I will file exemption, my lords. I was there in the morning, my lords.
This is not correct. So. So you are seeking time.
Yes, my lords.
Learned advocate, please.
Pavana.
In the absence of application, my lords, so warrant may be issued, my lords, to the accused.
My lords,
Warrant was issued.
It should be issued, my lords. They have-
No, my lords.
Warrant not executed.
No, my lords, warrant may be issued, my lords. They have not made any application for exemptions today. You
Morning
ought
he
to,
was
you ought to
there,
be
my
present
lords.
before the court today.
No, if warrant, whether we had issued warrant.
No, no, my lords.
Not issued.
My lords, I will
No,
file.
no, she is a notice has already been served. Registered. Notice,
My lords, I
notice was
will-
already
You are
issued.
for the.
It was a notice, my lords, to the
I
police.
will file exemption of
You are for the accused.
accused, my lords.
The warrant has to be issued. There's no exemption.
Lords, I will file.
Learned advocate, so and so, 6 time to file wakalatnamas, 10 over to 14th June. June. On the next date, unless the proposed contemner personally remains present, the court will be compelled to issue warrant to secure the presence.
Please, my lord.
So ask your client to remain.
Please, my lord.
Office objections along with counsel submission, seal number 61.
Your Lordship,
Ashok GV.
in this matter, an interim order was passed in favor of the complainant for non-interference of the partnership bank account. The office objection raised is on why accused number 4, 5, and 6 are made parties. These accused are basically the personnel of the bank account who we have been, who the complainant has been talking to regarding the interim order, and despite knowledge of the interim order, they have marked lien on the bank account. So they have essentially aided and abetted to the contempt, because of which we have made them parties.
No, you go under 2A. You
Your
have
Lordship,
taken the view
yes, under section 11, we have approached this court of the.
that we do not permit in ordinary matters.
Your Lordship, I have case law to show. There's a Madras High Court full bench decision which shows that we can, like, these third parties can be made party and
They are
can.
not full bench.
No, we have jurisdiction. Why we decline to entertain jurisdiction are two things. We have jurisdiction coupled with discretion.
Yes.
So in matters like this, since you have an alternate and more efficacious remedy of proceeding under Order 39 Rule 2 capital A as amended now, you should explore your remedy there only. You have to work out your grievance there before the same judge. That's how we have already taken.
Okay. Your Lordship, may be given, the order
But-
might record that liberty is given to approach the commercial court.
Admittedly, the complainant has remedy under the Order 39, Rule 2 capital A of the Code of Civil Code of Civil Procedure 1908. Full stop in that view. The court is not entertaining the present contempt application, relegating the complainant to the said recourse. Full stop. The such liberty is reserved for the complainant, however, without expressing any opinion on merits. The present proceedings are accordingly disposed.
62 urgent, seal number 63. Dave Shetty.
Appearing for respondents 1, 2, 3.
Subjections.
Lordships are having writ appeal 213, my lord, for the purpose of reference.
63.1 is also yours.
Both,
There are office
both against the same order. Office objection was, translation was sought. We had given a counsel submission that in the other case, court has already passed an order. In case of requirement of that translation, appellant will have to produce. The same may kindly be taken for the other appeal also. Briefly, the facts are this, my lord.
Essentially, section 25.
Essentially, section 25, all that I say is, in this Malnad Development Foundation is the society running certain education institution, appellant number 1. Now there are two groups, one led by respondents 5 and 6, appellants 1 and 2. On this day of holding of the general body, according to us, a violent incident took place which resulted in beating up of some of the second appellant herein. And thereafter, suo moto, someone announces that he is elected. All these things happened. For a moment, leaving that, my lord, your lordship may kindly see annexure J, the order passed by the authority. Page 200, my lord. Translation is at page 200, annexure J. It starts from page 186. Kindly go to page 200. Bottom, my lord. On examining, your lordship got it, my lord. On examining carefully are the aforesaid factors, the following decision is taken. Malnad Development Foundation Sagar is a society registered under so-and-so as per the registration number. Up to the year 2019-20, annual documents of this foundation is submitted and to the authority by obtaining acknowledgement. 56th General Body meeting of the said society is scheduled to be held on 17/3/22 and this notice was issued. As per clause 15 of the bylaws of the society, management board has powers to call for general body meeting. The date of 56th general body meeting is fixed as 17/3/22 and notice is issued on 23/2/22. But proceedings of the meeting for having decided in any management board meeting as per the bylaw of the society to fix the general body meeting are available. Due to this, not fixing the date of annual general body meeting by placing agenda in the management board meeting as per the bylaws of the society in this connection amounts to clear violation of the bylaw. In furtherance, permission of the president of the society, Shri so-and-so, is not obtained. Non-receipt of meeting notice by the president of the society 2 days prior to annual general body meeting gives rise to suspicion. Then, my lord, this is the relevant portion. Great confusion is caused in the annual general body meeting claimed to be held on 17/3/2022, and it is clear that untoward incidents took place. Due to this, and from the statement of the president of the society, KH Srinivas, it clearly appears on the word should have been prima facie, my lord, they have used translation is made as outlook. Due to this, and from the statement of president, it clearly appears from prima facie that 56th annual general body meeting was not held in proper manner. 30 persons have filed written representation claiming to be members of Malnad Development Foundation. In the said representation, it is requested that nullifying the self-declaration of Harnath Rao and Shripad Rao to be president illegally and contrary to the bylaws of the society and to hold fresh election. Due to this, it is corroborated that annual general body meeting of the society was on 17/3/22 was not held in proper order. On examining the proposal submitted by two factions arising in the 56th annual general body meeting, requesting to accept the documents filed by them and to issue the acknowledgement, no document substantiating to clarify that the said meeting was held in proper manner are available. Therefore, both the proposals submitted seeking acknowledgement are not acceptable. Then what he does is, he says it is not acceptable, I am not issuing acknowledgement for any one of that. Further, he proceeds that it is an education institution. I am making a report to the...
of these institutions. The registrar of the society's concerned jurisdictional authority appoints the ARCS to be the administrator.
No, he has not done that. What he says is, I am sending a proposal, report to the government that annual general body is not properly held for the purpose of considering this. That is the order.
Yes.
Now the learned single judge says, two apparent mistakes. I don't know how it happened. Page 34, para 14 of the order.
Yes.
Para 14, my lord.
The
petitioners in the first petition, that is respondent number 5, The petitioners in the first petition have produced a plethora of documents to demonstrate that they are conducting the affairs of the society. The claim is that petitioners in the first petition and petitioners in the second petition are all elected members of the society. Second petitioner in both the petition claimed to be the president of the society. On 25/3/22, petitioners in the first petition claimed to have submitted a representation along with all the details as was necessary under section 13 of the Act. Later on, they have followed it up with several representation. Kindly see the next sentence. A rival claims sprung up in the companion petition when the second petitioner therein appears to have registered a complaint with the second respondent seeking to conduct an inquiry under section 25 of the Act. This is not what at all that is done. In fact, the first claim was section 13 application was made by the appellants herein. That is available at Annexure J, page 186.
What was challenged before the learned
Then next what happens is, learned judge says no, rival claims sprung up later. Then he says, therefore, the issue was shrouded with certain disputed questions of fact with regard to the way the election was conducted or the way AGM was held. Petitioners in the first petition had submitted certain representations, which were 4 in number, not considered by second respondent, district registrar of societies. This drove the petitioners in first petition to approach this court by in WPSO and court by the order disposed of the writ petition by following order.
Both the factions had filed the writ petition.
Writ petition.
They had challenged the very same order.
Very same order.
Yes.
Now the learned single judge, with all the due respect I would submit, has donned the role of the district registrar and holds that the claim of the first petitioners is valid. The petitioners in the second petition can go to civil court, do all that, which according to my respectful submission, totally exceeds the power of judicial review normally exercised by this court. For a moment, allowing that this also could have been done, I have a much more stronger objection to the order. There is an entire episode is recorded. It is video recorded. CV footage is available. The minimum that learned single judge should have done in case he were to decide the matter finally, the relevant and the most specific material available was that. Without considering that, he passes the order. Now, learned judge takes the view, it is like district registrar setting aside the election. Your Lordship may kindly see that matter has been already concluded that any order under section 13, either accepting or rejecting the claim, will not in any way validate the election or set aside the election. That is the view taken by this honorable court in the division bench. Para 10, my lord.
What is that WP 12702 of 2020?
12702 at an interregnum, they approached the court saying, till now, district registrar has not passed the order. Court directed, you consider and pass the order. Second faction, that is present appellants, had also filed a writ petition. Court said, both the factions should be heard and both the applications should be considered. Kindly see para 10, my lord, in this or judgment of this court.
Was there interim order?
There was an interim order.
In your favor?
Yes.
In their favor, an interim order was passed. We moved an application for vacating. Vacating application stage itself, matter was heard.
Order was in operation for how long?
Order was in, order was in operation for about 2.5 to 3 months.
3 months.
3 months.
When the stay was granted?
In the writ petition.
Where do you get that? That's page 224.
We're asking the date.
Yes, ma'am, that is 1st September 2022. 1/9/2022.
And the order has been made 2nd January 2023.
Yes.
Since last 1.5 years, things are moving this way.
This Lord, one day I in fact made a submission. I have a difficulty in getting this matter listed. Somehow it is a jinxed case. Now, my Lord, your Lordship may kindly see para 15. If that were to be done of the impugned order, page 40.
40.
40. The issue now is whether by a stroke of pen, third respondent could have annulled the proceedings of the AGM and its result that had happened on 17/3/22. As observed herein above, the learned counsel for the petitioners in the first petition has produced plethora of documents to demonstrate that the petitioners in the first petition are managing the affairs of the society after 17/3/22. To the contrary, there are no documents produced. This is somehow probably it was reserved. Learned single judge has overlooked. There are no documents produced by the petitioners in the second petition seeking to demonstrate that they are managing the affairs of the society. Documents are produced to demonstrate that the petitioners in the second petition sought to register a complaint before the jurisdictional police, but no action has been taken. Name of particular police constable is also indicated, but that is neither here nor there. There is no document produced to demonstrate that they have sought to register FIR before the jurisdictional police under section 154(1) CRPC and had not been registered. No document is produced to show that efforts were made to register the complaint under 154(3) of CRPC. The effort of the petitioners in the second petition to register the complaint remains only an effort without any evidence. Therefore, this court is of the considered view that petitioners in the first petition, having produced a plethora of documents to the effect that they are entitled to manage the affairs of the society, second respondent had to act under section 13 of the act in terms of the order passed by this court. Then kindly see the operative portion.
That WP 12702 of 2022, that WP was filed by whom?
That WP was filed by respondent number 5.
There the direction was given.
Direction was given to consider.
That's what.
And it had a companion petition by the other side. Consider both the applications given by both the parties and then take up the matter. That is also quoted.
17127.
Yes, my lord.
Is your petition.
Yes, my lord.
12702 of theirs.
Huh.
Yeah.
Just
12702 is
check up
my
the number,
petition.
my lord.
Is yours.
Yes, Lord.
First
There-
one is yours.
First one is mine.
Second one is
Second
theirs.
one is theirs. They sought for review of the order passed in that petition.
No, we did not seek review.
The prayer.
We said we are the first persons who have made the application under section 30. Kindly see page 176.
No, how, whether you are first person or second person, is it relevant?
It is relevant because learned single judge says you have made a rival claim is sprung up later. On the other hand, that should have been the objection to their claim. Learned single judge, as your lordships noticed, says the rival claim sprung up after their application in para 14 at page 35. Kindly see.
But there is one judgment, Justice, Honorable Justice Dattu, as my lord then was, holding that the annual returns, these are filing of annual returns. In deciding which annual returns to be accepted, whether X comes first or Y comes first is irrelevant.
That would have been my submission.
And you have argued
if-
that matter.
If that question was asked, that would have been. On the other hand, the learned single judge page, I will only put it this way. Kindly see page 186. Reference number 1. Proposal dated 18/3/22 of NH Shripad Rao, that is the appellant before your lordship. Then proposals dated 21/3, 23/3, 4/6/22 of Karnataka. Earliest proposal by them is on 21/3. That is 4 days after the holding of general board.
No civil suits are pending between the parties.
No civil suit. On the other hand, emboldened by this order accepting their claim, they have passed a resolution removing 54 members because we have taken up the matter in writ petition and writ appeal.
Your client is Shripad Rao.
Shripad Rao and
Your client is, are they
Karnataka.
related? Not related.
Not relatives.
No, just we wanted to.
Yes, yes.
The power, the apex court said, I think in Kalinga Tubes, the apex court said, the power of the writ court, be it under 226 or 227, is coextensive with powers of the authority whose proceedings are brought before the court for examination.
That's why I said.
That's number one. Number two, the society has been running educational institutions. Therefore, the management of the educational institution should go on till dispute is resolved one way or the other in due process of law. These two things appear to have impressed. The first one is not articulated. It is an inarticulate premise, to borrow the words of Cardozo. The second one is apparent.
Second one is not apparent. Second one is by mistake. There were two things that were before the court. First is whether violence has a place in running of these institutions. If this order is to be this thing, someone can just barge in, beat up everybody, of which a record is available. Video record, CCTV footage is available.
But how in writ court?
Therefore, the learned judge should have sent it back. If the learned judge was not ready to look into that, then he could not have utilized the powers of the original authority. I'm not saying 226, no final order can be passed. Far from that. But your lordships have always cautioned that this sort of consideration at the writ court level, I would even now say, my lord, kindly have a look at that video footage and pass any order. Because it is a case wherein a non-member who happens to be MLA with the support of about 30 people who are not members, barges in, beats up the office bearers.
You can say beats up persons. How we will decide who is the office
No,
bearer?
no.
That
They
is
were
the
previous-
question.
No, on that day, they were the office bearers of the previous committee. On that day, their term had not expired.
The learned judge felt in his logic that educational institutions are big. It is said that in the order it has been said like that. It is said that.
If that were to be said, is it that we were not in a position to manage it?
No, question
Why
is-
it should go to them?
If assume for a moment,
Please,
he would have come in appeal.
he would have come in appeal.
Then he will say same thing. Why to Mr. Patil?
That is why I said, once that stage came, the minimum that I request, either before the learned single judge or before this honorable court, please see this video recording. If something of that sort is to be permitted even indirectly, upheld even indirectly, it is like giving license for violence to set in.
Whether your client lodged any complaint, private
Yes,
complaint?
we lodged the complaint.
Got
Not only we lodged the complaint, it was not registered because of political reasons. It resulted in an agitation being taken up by all of us. Ultimately, because of our agitation, SP came and registered this thing. But what the learned single judge says is, you should have gone under 154(3) and filed a private complaint. There are several things I could have done. That is not the.
After SP took over that, then what happened in the investigation?
No, what all that they did is register. Till
Crime-
then, they had not registered the FIR. Now they have registered the FIR. Now a charge sheet is submitted.
Crime is registered in crime number?
I'll just give the.
Crime number 269 of 2022.
Crime number?
No, 269 of 2022, my lord.
269 of 22.
2022.
Charge sheet is filed on?
That is not made available.
Charge sheet is filed. Filed on?
File, my lord, I'll give the.
Under which provisions of IPC, against whom?
Including the present respondent number 5 and 6.
For
There
offences?
are other persons also.
Whether the cognizance of the offences has been taken? Is it converted into CC?
It is numbered as CC is this thing, my lord, but I'm not sure.
It is not on record. Only FIR is on record. FIR is not filed. Complaint is filed after lapse of 4 months of the incident. I'm not subject to correction. Not the name of my clients are not reflected in the FIR.
For offences, what are the offences?
But
they have
offenses
alleged
not
in the
under
FIR?
section 323, 324, 506 and 149. Lord, what happened was, may I, Lord?
Grievous assault and grievous hurt and assault.
Yes. Lord, what happened was, Lord, after Lord, our writ petition was filed, seeking for direction, Lord, to consider our application under section 13. But the matter was disposed of. After which they filed a writ petition after 1 month. They said they sought for review of the order passed in our writ petition, which Lord had come up before my lords. And lords disposed of the matter, saying both the parties can appear before the registrar and submit their statement, including the issue as to who is entitled to file section 13 application. That is the scope not of inquiry. But not what registrar does is he goes a step further. He entire basis is the order of the honorable court, but he goes further and he not virtually sets aside our election. Therefore, the learned single judge says
that is contrary to
he
Sara,
cannot.
Sara Govindu.
Yes.
Contrary to Sara
Yes,
Govindu.
Lord. Sara Govind and also not the full bench decision of the Madras High Court. He says not that you cannot set aside an election in this fashion.
I will, if that is what is relied upon by the learned single judge, my lord. In Sara Govindu case, if it is not confined to facts of that case, then the view as stated is totally wrong to the extent of being, kindly see section 13.
1.3
of the society's registration.
Please read.
Please. On or before 14th day succeeding the day on which the annual general meeting of a society is held, there shall be filed with the registrar a list of names, addresses, and occupations of the members of the governing body then entrusted with the management of the affairs of the society, and a copy of the balance sheet and income and expenditure account audited by a person who under section 226 of the Companies Act can act as an auditor of the companies registered under the Act.
a full bench, two full bench judgments. One you have argued. When the party should approach the civil court, you have argued.
That is in case of section 25 inquiry.
This matter traveled to 25 also,
It did
pursuant to
not-
13.
It did not travel to 25.
No, it traveled to 25. You have read the English translation.
English translation, the inquiry could have been only under section 25 is how it is sought to be put. Now, your lordship may kindly for a moment look
The
at.
recommendation for appointment of administrator would happen only if 25 is invoked, not otherwise. From 25 to 27A?
Yes.
Which is that? That will-
27A, my lord, is
27A.
administrator. 25 is inquiry.
Kindly see, that may not be the correct position, in legal terminology. Kindly see section 27, chapter. Notwithstanding anything in this act.
Section?
1A.
27A. my lord.
27 capital A. Notwithstanding anything in this act. A, where any society on account of pendency of the litigation or otherwise has not held or is unable to hold annual general meeting. B, where the term of office of the members of the governing body of the society has expired and a new governing body has not for any reason been constituted. C, where on a report made by the registrar or otherwise on inquiry, state government considers it necessary in public interest so to do. The state government may by order published in the official gazette appoint an administrator for such society for such period not exceeding 6 months as may be specified in the order to manage the affairs of the society. There is the highest that the registrar can do is, in case he comes across the information, he can send a report. Report can be either under section 25 or even otherwise. Because now in a case under section 13, he records a finding, untoward incidents happened in this general meeting, referring to the interruptions. Then he says, I am not in a position to accept the say of both these factions with regard to proper holding of the general meeting. Therefore, I don't accept the section 13 applications given by both the parties. Then independently, he sends a report. On that report, there is no question of appointment. On inquiry, government may do. On inquiry, even otherwise it can do. Now, two things, my lord. Learned judge feels the order, impugned order therein amounted to setting aside the election. An order under section 13. For that, my lord, my answer is division bench of this court has said in that decision, para 10 may kindly be seen.
Sara Govindu.
No, not that one.
The
other decision,
one
writ
which-
appeal. Muniswamy case. Paragraph 10.
We have perused section 13.
We have perused section 13 of the said act. Section 13 of the said act contemplates filing of balance sheet and annual general list of governing body with registrar within the time frame provided therein. On the face of the section, it is apparent.
So election issue question of that could not have been.
It does not confer power on the deputy registrar to hold an inquiry on the issue of legality and validity of elections. There is no power conferred on the registrar under section 13 of the said act to decide on the basis of list of governing body whether governing body was lawfully elected. Therefore, the learned single judge could not have read the endorsement dated so and so issued by the deputy registrar as an order adjudicating upon the legality and validity of the election held on 5th March 2017. Then, my lord, your lordship may kindly go to para 13.
It fixes parameters of section 13.
Yes, para 13, your lordship may kindly see. as stated earlier, learned single judge was impressed by the non-approval of the list by the deputy registrar. Secondly, he was of the view that appropriate way of deciding the list was to order holding fresh election. As held by us earlier, the so-called non-approval under section 13 of the Act cannot be termed as an adjudication on the legality and validity of the election dated so and so. When there was no specific challenge to the legality without dealing with so and so, they could not have directed the race. Therefore, that order. Now, the next step, the objection taken against the report of the learned district registrar is, he has sent a report recommending for appointment of administrator. Now, as an officer, if he comes across a situation that, which according to him, there is no proper meeting held, there is no proceedings that have taken place, and this is an institution which is running education institutions. Therefore, he says in his words itself, being an institution running several the colleges, etc., government should consider all that he says is
appointing, says to the administrator, etc., which you have read already.
Government on this recommendation is not in a position to appoint by itself. On an inquiry, after the report or otherwise, on an inquiry, it may appoint. My major concern in this case is, my lord, it was a case wherein a non-member, being an MLA, barges in, takes law into his hands. These are not things which should be permitted, whether it is the other side which becomes the president or I become the president. These are not
Have you made a MLA also a party, not a party?
Not in this.
Have you taken up that contention in your writ appeal, objection statement?
In my writ petition, that is the main contention that I have taken.
But you have not made him a party.
I have not made him a party. What was done was a very clever way of doing it. MLA walks in with the previous president.
If you wanted to, the case which you want to project before us, for that you should have laid a foundation is one thing. That foundation is meaningless unless the person against whom we are making allegation is made a party your nominee.
That's why I'm saying there is a video footage recorded. How it happened is with the previous president, MLA walks in. 25-30 supporters of this MLA who have nothing to do with, they are not members or anything.
What do you say about 13 parameters being apparently, arguably, transcending to section 25, 27A?
That is precisely my case. Lord, what happened was, the direction was to consider section 13. Now, Lord, what the registrar did is, he cancelled our election. He nullified our election. But I'll just read the portion which is they themselves have produced the order copy. He says, he nullifies our election. And Lord, he directs the government that an administrator be appointed. Therefore, my Lord, single judge rightly said, you cannot set aside an election because he has no jurisdiction to do so. But under section 25, but he could not set aside my election because it is not a section 25 inquiry at all. Even otherwise, not section 25, Lords are aware, he cannot not set aside an election. And Lord, we were carrying on Lord the activities of the college. Lord, I've produced lot of documents to show that Lord, we are running the institutions. We are paying Lord everything, Lord, the teachers, everything Lord is paid by us.
If the now, documents pertain to anything previous to the date of passing of interim order in the writ petition, then all those things would have come.
This is precisely the question my lords had asked me before granting the interim order in the writ petition. Lord, I'll show the document. I showed the document that Lord, my clients on 23/5/2020 itself, Lord, they are carrying on with the administration of the society.
I don't find the submission of my learned friend. Please,
Wherefore, with regard to 56th annual, it begins
Please,
like that.
please.
Wherefore,
For-
with regard
Therefore,
to
with regard to
56th annual general
56th
body meeting,
annual general body meeting dated so
held
and
to be in
so,
proper manner.
held
and
to
there
be
are-
in proper manner, and there are no corroborative documents with regard to the genuineness of the management board out of the two management boards to be constituted in the said meeting. The said two management boards content to be constituted are hereby nullified. This is a wrong translation. Your lordship may kindly go to page 184, my lord, Kannada portion. One 184. Last but one para. I'm sorry, my lord, it's in Kannada. I would. ಐವತ್ತಾರನೇ ಸರ್ವ ಸದಸ್ಯರ ಮಹಾಸಭೆಯಲ್ಲಿ ಉಂಟಾದ ಎರಡು ಬಣಗಳು ತಮ್ಮಲ್ಲಿ ಇರುವ ದಾಖಲಾತಿಗಳನ್ನು ನೀಡಿ ಅವುಗಳನ್ನು ಅಂಗೀಕರಿಸಿ ಸ್ವೀಕೃತಿ ನೀಡಲು ಸಲ್ಲಿಸಿರುವ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿ ಸಭೆಯು ಕ್ರಮಬದ್ಧವಾಗಿ ಜರುಗಿದೆ ಎಂಬ ಬಗ್ಗೆ ಸ್ಪಷ್ಟಪಡಿಸುವಂತ ಯಾವುದೇ ಸಮರ್ಥನೀಯವಾದ ದಾಖಲೆಯು ಕಂಡುಬರುವುದಿಲ್ಲ. ಆದ ಕಾರಣ ಸ್ವೀಕೃತಿ ನೀಡಲು ಕೋರಿ ಸಲ್ಲಿಕೆಯಾಗಿರುವ ಎರಡೂ ಪ್ರಸ್ತಾವನೆಗಳು ಒಪ್ಪಬಹುದಾಗಿರುವುದಿಲ್ಲ. ನೆಕ್ಸ್ಟ್, ಮುಂದುವರೆದು ಸೋ ಅಂಡ್ ಸೋ ಅಡಿಯಲ್ಲಿ ಹಲವು ಶಾಲಾ ಕಾಲೇಜುಗಳು ಸೋ ಅಂಡ್ ಸೋ ಸಿಬ್ಬಂದಿಗಳ ಹಿತ ಕಾಪಾಡೋದಕ್ಕಾಗಿ
ಮಲೆನಾಡು ಅಭಿವೃದ್ಧಿ ಪ್ರತಿಷ್ಠಾನ ಸಾಗರ ಇದರ ಸದಸ್ಯರೆಂದು ಹೇಳಿಕೊಂಡು 30 ಜನರು ಲಿಖಿತ ಮನವಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಮನವಿಯಲ್ಲಿ ಸಂಸ್ಥೆಯ ಬೈಲಾ ಮತ್ತು ಕಾನೂನಿಗೆ ವಿರುದ್ಧವಾಗಿ ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ಮತ್ತು ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ಇಬ್ಬರೂ ತಾವೇ ಅಧ್ಯಕ್ಷರೆಂದು ಘೋಷಣೆ ಮಾಡಿಕೊಂಡಿರುವುದನ್ನು ರದ್ದುಪಡಿಸಿ ಹೊಸದಾಗಿ ಚುನಾವಣೆಯನ್ನು ಧರಿಸಲು ಕೋರಿಕೊಂಡಿರುತ್ತಾರೆ. ಇದರಿಂದಾಗಿ
Page 185, not the operative portion of the.
ಇದರಿಂದಾಗಿ
It also says nullification. The elections are nullified. Page 185, last paragraph. Fifth sentence.
ಆದ ಕಾರಣ ದಿನಾಂಕ 17/3/22 ನಡೆದ 56ನೇ ಸಾಲಿನ ಸರ್ವ ಸದಸ್ಯರ ವಾರ್ಷಿಕ ಮಹಾಸಭೆಯು ಕ್ರಮಬದ್ಧವಾಗಿ ಜರುಗಿದ ಕುರಿತು ಹಾಗೂ ಸದರಿ ಸಭೆಯಲ್ಲಿ ರಚನೆಯಾಗಿದೆ ಎಂದು ಹೇಳಲಾದ ಎರಡು ಆಡಳಿತ ಮಂಡಳಿಗಳ ಪೈಕಿ ಯಾವ ಆಡಳಿತ ಮಂಡಳಿ ನೈಜವಾದದ್ದು ಎಂಬ ಬಗ್ಗೆ ಸಮರ್ಥನೀಯವಾದ ದಾಖಲಾತಿಗಳು ಇಲ್ಲದಿರುವುದರಿಂದ ರಚನೆಯಾಗಿದೆ ಎಂದು ಹೇಳಲಾದ ಸದರಿ ಎರಡು ಆಡಳಿತ ಮಂಡಳಿಯನ್ನು ರದ್ದುಗೊಳಿಸಿ ಸಹಕಾರ ಸಂಘಗಳ ಸಹಾಯಕ ನಿಬಂಧಕರು ಶಿವಮೊಗ್ಗ ಅವರನ್ನು ಕರ್ನಾಟಕ ನೋಂದಣಿ ಪ್ರಕಾರ ಆಡಳಿತ ನೇಮ
that is 27A ಗೆ ರೆಕಮೆಂಡ್ ಮಾಡಿದ. He has not set aside the election of anybody.
This is setting aside. This is really setting aside of election of the.
It is not.
No, it is not.
It is setting aside of
because
election.
Government may not accept it.
Registrar.
The two management board constituted are hereby nullified.
That is why Lord, when a single judge
And it is
interferes.
hereby recommended to appoint the assistant registrar of cooperative societies as administrator.
Yes, Lord. That is why when a single judge
That
interferes.
is a report under 27A.
It's a recommendation.
It's a recommendation.
What you say is the only government can do it and court should not have done it.
Government
It is
can
your
do
option.
it. Now, my lord, your lordship may kindly see the learned single judge taking upon himself about this deciding which is the NISA or the proper body.
As the full bench said in a civil suit.
It has to be, it can only be.
Oh, you go to civil court.
If I am to go to civil court by the direction of the court, that is like saying as far as they are concerned, I accept it.
If suppose if he were to be in
both-
appeal,
It should.
I tell him you go to civil court, same
no,
thing
it
he
is
will
not-
also say.
It is not that. It should have been left to If at all there was something material not considered, re-enquiry was necessary, it should have been sent back to the district registrar to do it. Or otherwise, it is for both the parties to approach the civil court. Your Lordship may kindly.
What should happen to the institutions, students, etc.?
For that, violence is not the answer. For that, government 27A is the answer. If such a situation arises.
But generally, writ courts assume the guardianship of students. There are such judgments.
If that was to be assumed, my lord, I would have no objection if the learned single judge has looked into the video footage.
2019 for Sarvapalli Ramaiah.
Yes, my lord. Your Lordship may kindly go to para 41. In this case, the impugned decision taken pursuant to the orders of the court was based on some material. It cannot be said to be perverse to warrant interference in exercise of High Court's extraordinary power of judicial review. A decision is vitiated by irrationality if the decision is so outrageous that it is in defiance of all logic. And no person acting reasonably could possibly have taken the decision having regard to the material on record. The decision in this case is not irrational. A decision may sometimes be set aside and quashed under 226 on the ground of illegality. This is when there is an apparent error of law on the face of the decision, which goes to the root of the decision, or in other words, an apparent error, but for which decision would not have been otherwise. 43. Judicial review under 226 is directed not against the decision, but against the decision-making process. Of course, a patent illegality and an error apparent on the face of the decision, which goes to the root of the decision, may vitiate the decision-making process. In this case, there is no such patent illegality or apparent error. In exercise of the power under 226 of the court, the court does not sit in appeal over the decision of the impugned, over the decision impugned, nor does it adjudicate hotly disputed questions of fact. Of course, my lord, the other decision. There are two parts in the impugned order of the district registrar. First part of it, district registrar says, the things have not gone on in a manner in which AGM could have been held. Therefore, I am not satisfied about the claim of both the factions. That is the first part of his decision. In that decision, learned single judge, if we are to find fault with, it could have been only on facts. Then matter should have been remanded. Is a recommendation to the government. Government may accept it, may not accept it. And as far as the learned judge taking upon himself deciding about this, I would respectfully submit, apart from other objection, my main objection is, if that were to be done, the material that was highly relevant material that was available was the video recording of the meeting. Without looking at it, the learned single judge could not have found fault with the order of the district registrar.
Ah,
Of course, my lord, in Tata Cellular, which is the basis for all other decisions, that would be para 77 and para 94. It is the decision-making process and not the decision. And if the decision is to be reversed, it is like acting as an appellate authority. Then please consider my materials also. Mine is not a rival claim which came later. Mine was the first claim.
yes. Always in administrative law, we have been taught since decades that the focal point of writ jurisdiction is the decision-making process and not the decision. But what is decision-making process? Whether that will cast a shadow on decision-making, very beautifully Lord Atkin has explained. Anyway, we'll do. Thank you so much.
That's why I said, not that 226, it cannot be done or anything. But if it were to be done, the objection that we take about an administrative order is relevant material is not considered. Material on record is not considered. In this case, relevant material on record is not considered by the learned single judge.
Please.
And one other thing, my lord.
It's time to file an application.
After vacation, I'll eat.
Number 65. BH.
My lord, I appear for the government.
Lord appearing for the appellants. Lord, I seek 1 week's time to comply with the office of.
My lord, paragraph 4 of the order of the learned single judge may be seen, my lord.
23 days delay.
Yes. May be condoned, my lord.
These cases are transferred to apex court now.
Yes, my lord. About your
Cases are transferred to apex court.
My lords, it has gone to the apex court, but we had.
No, appeal should be entertained. If cases
Please,
are
my lords,
transferred.
I'm appearing for respondent number 1, Union of India. My lords, I'm supporting the impugned order. My lords, the learned single judge has rejected the writ petition on that ground in paragraph 4.
Correct.
So therefore, my lords, I'm seeking for dismissal of the writ appeal also.
Whether these matters are being considered by the apex court
Yes, my lord.
Please, my lords, it's already
Which?
become a transfer case.
in TC number
Please, my
137 of
lords, please.
2013.
Please, my lords.
My lords,
And this very body, Indian Radiological Association, the other chapters are before the Supreme Court, my lords. It was their matters that were transferred.
It also has to be. Which are already transferred. And consideration. Transferred by what order?
This case is also.
My lords, a transfer petition was filed by the Union of India, my lords. It's at page 91.
So all cases are transferred by order of the apex court.
My lords, not all cases, my lords.
No, this, madam, this is transferred.
My lords, I'll tell your lordships, initially there was a writ petition filed before this honorable court, which was transferred. That was dismissed for non-prosecution. Thereafter, this second writ petition came to be filed. Now, my lords, this case has not been transferred, but the very same issue is before the Honorable Supreme Court in a writ petition which was pending, which has since been dismissed for non-prosecution. Therefore, my lords, the learned single judge has said the same rules are under challenge, my lords.
My lord, the second sentence may be seen, my lord. These are not transferred petitions that are pending further orders at the hands of the apex court, but these are all cases which are already transferred and pending consideration before the apex court.
Whether that is true is our question.
Pardon?
Then I'll verify and make my submission.
Verify, otherwise it will be put to.
No, no,
My
my
lords,
lord,
it's
my
at
lord,
page, my lords, it's at page 91, my lords. The proceedings in the transfer case 324 of 2014. It was last listed on 17/7/2023, my lords.
Which is this case?
My lords, this is the transfer case, my lords, in which
TP 324 of 2014.
lords, it's TPC, my lords.
That's what, C is civil.
No, my lords, transferred case. When it's already transferred, it becomes TPC.
TPC.
Please, my
Under
lords.
the Supreme Court rules of practice.
Please, my lords. I have made the submission even in my objections.
May
my
not
lords.
be. See the above, the transfer case civil.
My lords, I'll put transfer case, transfer petition and transfer case TC, my lords. It's already become a TC number. I have stated that in my statement of objections.
That's all right. Where do you show that even the case of the appellants was transferred to the apex court? Show that.
My lords, that is my submission.
Whether same issue is being debated before on the floor of the apex court is one thing. Case is before the apex court is another. Under the Supreme Court
My lords,
rules.
this writ petition has not been transferred. A previous writ by the same petitioners has been transferred.
Correct, but this is not.
This is.
Then this is an error apparent on the face of the record.
Either way, this. Either way, this discussion will not benefit.
Pending before the apex court. This case is not transferred. But then they have filed, but that's wrong order. This order is must be another case. Not this case. Maybe by their argument here. So the judge was swayed. Yes, the apex court say, unless we direct that we should not touch the papers, we should go on deciding upon it, earlier we want. Once it is pending before us, you should. Therefore, also we should do it. This all needs to be set aside. He proceeds on the assumption. Matter. Proceeds on the assumption. Matter is not pending. This is a separate case. Whether separate case could have been filed is another argument. But fact remains, this matter is not pending before the apex court. How can you deny justice to the citizen on an assumption that his case is already pending before the apex court? Show that.
My lord, I'll verify it, my lord may have.
Lords, this case is not pending, but an identical issue. Very well, my
Identical
lords.
issue is
Very
pending
well.
before the
I'll-
apex court is no answer because law is settled now. Apex court said, unless we direct, the High Court should go on deciding the matters.
Very
Earlier
well,
view was, once matter is pending before the apex court, all other courts in the country should await. Now that we change it now.
Very well.
Therefore, you have to tell responsibly, you have to make a statement
My
that matter is pending or not. Who told before the learned single judge matter is pending?
My lords,
Perhaps you have said that.
My lords, I have stated it in my statement of objections, my lords. Kindly see page 110, my lords. That is not the manner in which I have stated it. My lords, kindly see page 110.
Paragraph 2.1.
Paragraph 2.1. My lords, I only sought to keep this writ petition pending till the decision of the Honorable Supreme Court, my lords.
Kept pending.
Please, my lords, that is the writ.
Right. But when dictation is being given, you should have told the court, sir, it is not like that. It's not pending. Issue is pending. Case is not transferred. Anyway, you have taken up contention, it should be kept pending. Appears to be sensible.
Let it.
Just verify and tell us.
Lord, I take notice for respondents 2 to 4.
2 to 4.
My lords,
And you appear
I'm
for one.
appearing for respondent number 1. My lords, I'm on advance notice. If your lords are issuing notice, then I'll accept.
Notice and respect.
With your lordships kindly.
The next
Serial
matter,
number
my lord.
68. We have complied the order.
Complete.
Next matter, my lord.
60, who appears?
68.
Complainant is not here.
I am here.
Here. It's complied with.
I'll verify. I have no instructions with regard to
To consider their representation.
Monday we'll have.
Monday 2/3.
Next matter, my lord, my house is being demolished. Today it is slated for demolition. I moved the matter day before yesterday for your lordships.
Demolition.
Yes, my lord.
Demolition of building.
Yes, my lord. They give me a notice, my lord, saying that it will be demolished today. I received two notices are issued pursuant to the order of the learned single
They're
judge.
constructing without sanction plan.
A sanction plan is there for the ground floor, my lord. Subsequently, we had entrusted the matter, the engineer
First and
to.
second floor you are constructing
That
without
is only in relation to the first and second floor. Third floor, we have demolished.
You have demolished third floor.
Third floor, we have demolished. Only thing is, we had submitted a sanction, renewal of the sanction plan or a fresh plan, so that everything can be.
You see notice in status. Notice
Status.
returnable on
Same.
29.
May I make a request?
With
your lordships-
Status quo.
Status.
May I make one request?
And the petitioner shall not further construct.
Yes, sir.
With your lordship's most gracious permission, my lord, I may be forgiven, my lord. My case is serial number 69. My lord,
Yes, Mr.
I'm online, my lord, 69.
I am the petitioner party in person. The CET examinations are going on today and tomorrow. Like it be announced during the vacation. I am only requesting, my lord, I have filed an IA there saying that some seats, my lord, which are being allotted to KEA contrary to Supreme Court orders, should be offered as government seats. If it can be taken up on Monday in hearing on IM, that's all my request, hearing on IM, because the important matter is there at stake. Every year, my lord, the meritorious students are.
We may permit you to move the vacation.
But that will come for again final hearing. It is listed for final hearing. My only request, my
Whatever
lord,
want to you move vacation.
No, but if for final
On
hearing,
on Monday, we'll see.
Monday, my lord, it may be taken up on Monday for hearing on IM.
With your lordship's most gracious permission, my lord.
Public.
Serial number 67, your lordship may kindly recollect, that was a case wherein the order was not available. Therefore, up to today, your lordships have posted to make the order.
Respondent in that matter.
That order
Let-
appears to have
let-
been released now.
Order is released, reasons
Or-
are clear.
order-
These are not maintainable, my lord. Writ petition
Just-
is challenging
I-
authority to order.
I think, my lord, I am entitled to be given a minute's time. Order copy was uploaded yesterday afternoon. We have been able to take a copy of that, not the certified copy of the order uploaded. Now the matter may kindly be taken up on Monday or Tuesday, my lord. We will furnish this along with the
Taken up on
amendment
Monday or
petition.
Tuesday, Lord. My contention is writ
I
appeals
have-
are not maintainable. Writ petitions were
That's very
challenging.
well, very well, my
The
lord.
relief sought for quashing of proceedings before the criminal code.
Labor
Lord.
227.
Yes,
It is,
it's not maintainable.
It is not so, my lord. It is against the ED order. Writ appeal is fine.
We have given interim relief to you.
Yes, my lord.
With your lordship's most, sorry.
May I make a request?
You better don't use mic.
You don't
May I
need
make a
mic at all.
request?
Mr. Patil needs no mic.
I had not noticed that.
With your lord,
Directed to serve
Don't
copies.
take in, don't take in adverse way. This is
Lord, in
only-
this case,
No, no, no.
petitioner
It's a
may be
compliment
directed
to
to, my lord, appellant may be directed to serve copies on us, my lord.
Please give copies.
Please, your lordship's notice.
May I make one request, my lord?
I was arguing on matter. It appears the learned single judge sitting in the next court said, now that I have heard Jetmar Patil, let me pass the order.
with your lordship's most gracious permission, my lord.
So 23rd.
23rd.
Please.
With your lordship,
Order may kindly be extended till then.
with your lordship's most gracious
Maybe 2
permission,
weeks time may be granted.
Granted, all will grant.
with your lordship's most gracious permission, I'm on online. Your lordship,